Hello, everybody. You just missed an absolutely hilarious moment. I hit go live, but I didn't hit the second confirmation that I wanted to go live. Tiny Kitten was using my chair as a scratching post, and she got herself stuck as I was clicking the go live button. So it would have been funny. I wish it would have gone, but when I got her unstuck and I turned, I realized that I wasn't live. You are just so much. She's been rubbing all over me today, and she's super static clingy, which is why I had to wet my hair down before I could come on, because her. She wants to be by mama though, which is perfectly okay with me. Jerry, you have created 5 little monsters. Well, 4 little monsters and 1 giant monster. Tree goblins. They get more demanding by the day. Bandit's upset because I ran out of treats in the bathroom for her in her room, and she was very upset that I didn't produce them upon demand. And I told her I will bring them back to her. And she bit me. I know she understands me. So I squeezed out 2 licky tubes onto a plate and told her that will suffice until I get back. I agree, Tiny. I agree. This one's empty. I'm gonna have to get the ones off the shelf. Oh, wait a minute. Backups. Oh, of course, fur in the eye, fur in the eye. You got yours. You got yours, junk butt. Hello, Buzzy Pug. Hello, Jerry Matthew Boyd. Hello, Nana Laura. Hello, C-Rex. Hello, Manuel. Oh, you are so sweet. I love you. Hello, Donald Westerdale. Oh my. I'm retrograde is early this year. It's got to be. I know Auntie M says it's not time yet, but everything, anything, even a little technologically, electronical, whatever, is failing. I'm holding out for tonight, guys. I'm holding out for tonight. I used the new software. Oh, that reminds me. Give me 1 second here. I need to. It's gonna do the black spinny for 1 second. We should be good now. Oh boy. And then to hear what was it? volcanic eruption in Hawaii, and either that or earthquake in Philippines. I can't remember which. Manuel posted it in Discord. So, Jim Tidekey, I hope you're okay, buddy. I really do. Seriously. That was the first thing I thought of when I saw Philippines. I'm like, oh no. But my prayers go out to everybody in Hawaii and in the Philippines and anywhere else that's going through any kind of occurrence. Y'all are in my heart. Hello, Michelle Moreland. Hello, Megan. I'm so happy to see you. Hello, Joey Big Donuts. Oh, I'm so sorry. That sucks. I definitely hope you're able to get there and, be there for his family or attend the services or whatever it is if you want to. I hope you're able to do that, whatever it is that it takes for you to heal. I love you so much. Look at you. You inspired Michelle to start singing. Hello, Charlie. Thank you, Joey. You are so sweet. Blame Tiny Kitten. It was her fault tonight. It was her fault. She made me staticky. And then Bandit got bitey. I have to appease the pets, y'all. Yeah, they own me. Earl said it. Oh, God, Donald. Okay. That's awful. I'm sorry, that's hilarious. I love you guys so much. Hello, Eileen and Carlin. Hello, Spider-Man. Thank you, Jerry. You little monster maker. Ava heard your comment. She she reads them now. She's like, I know the word treats got written. I know it did. I must come investigate. Probably. It affects anything electronical, and Auntie M said that it's not supposed to start yet, but it's soon. But seriously, when retrograde hits, everything electronic fails, and fails bigly. Not unless you're part robot. You know, I do wonder about you. You might be AI. Thank you. Thank you so much for the news. I get my news from Manny. Golly. I hope everybody's okay. Yeah. Yeah. Yeah, despite being censored hugely today. Well, yesterday. That's what the problem was. So, my editing software, like you guys all experienced with me last night, wouldn't export. It first got to like 46.2 or something like that. The next time it was 27. The next time it was 22. It just kept decreasing how much of the video it would export. And so I emailed them, and I went online and looked up all of the troubleshooting issues and to see if anyone else was having problems. And Ava, stop. And then I decided, well, I'm going to find a workaround. So I thought maybe if I upload it to my cloud of CapCut, because you get a certain amount of storage for your monthly plan, that I pay for to have the ability to edit clips. So it makes me so mad. So thought I would upload it to the cloud, and then I would maybe export it from the web browser. Thought maybe the desktop software was what was having the issues. Came back and checked a while later, and the cloud upload failed, and it had a new message. And it said that my video content violates the community standards, and I would not be allowed to export it. So I decided I would get a new software. And I looked up each of the clips that I had. There were 4 that I had in the CapCut. And I wrote them down as to, what clips they were, and the dates and the timestamps, so I would know which ones to put into the new software. And one of the clips was grayed out to the point where I couldn't even access it to do anything but delete it. So now CapCut gets to decide what content I'm allowed to make and put out there. No, they don't. I could understand if it was, graphic material or illegal or something like that. No. You want to know what they're so mad about? You're going to find out in the last clip. Oh my goodness. Maybe it's something to do with the plates. Maybe there's some tectonic plate activity going on that we don't know about. I don't know. We should consult the big brains, the science-y people. Good. I hope you're able to. Even if it's just to stop and say hi, drop off a casserole. The stuff that too many people take for granted nowadays. Donald, quit it. Oh my goodness. Hello, Marcotti. And by the way, Donald, don't quit it. You guys are the best. You fell asleep and you left me to deal with the traumatic issues all by myself. It's okay, we just streamed body cams. No wonder the program's faulty. Oh, he always is. Yeah. No, it's clearly not. Oh. What? What do you think it is? Yeah. Let's have a guess. What do y'all think it had a fit over? Because it's actually okay. Yeah, it's bad, but it's actually not that bad. um, when it's here's the thing. When it's in context, it's not that bad. But if you take it out of context and you don't look at it as exactly what it is, sure. I guess you could say that it's, hateful. But there's no place to even appeal it. There's no place to say, "Hey, can you look at this video and this is why this is not what you think it is." No. Just an absolute immediate shutdown. You said bad word. I'm not going to say it. I'm not going to say it. I'm biting my tongue. For the sacrifice. Good luck finding one of those. Well, yeah, I know there is. I mean, they're forever shifting, but it's not their place. I mean, okay, yeah, I get it. I'm using their software, but I could understand it if it was the free version. Okay, it's a free version. You have every right to tell me what I can and cannot produce because I'm not paying you. Once I start paying you, and it's not cheap, like the one that I bought today, it's $100 a year, and that's on sale. It was on President's Day sale. So I had to pay $100, but good news is I get to cancel my CapCut subscription. But this new software is more advanced. And I say that regretfully. I can do more with it, but I don't need to. and having so many extra bells and whistles makes it so much more complicated. I just want to program it to work exactly how I know things work. And I can't. I can't. Okay, let me see. All right, I am all the way to the bottom. I have finished with the comments. So, on to the videos. Okay, so I have to explain. We go to North Dakota first, and I wasn't going to include the first 2 cases because they're not super exciting. But case 1 is talked about in case 2. And then case 3 brings up case 2. So it was like, okay, to get the full picture and context, because otherwise, I mean, I'm sure you'd get what he's saying, but you wouldn't fully get it. You wouldn't, you'll understand what I mean once you see everything. And then the very last clip, the audio and video were out of sync. I don't know what the issue was, but I mostly fixed it. Correcting that error is not very easy. The program that downloads the videos, it does so in fragments, and sometimes when YouTube is trying to shut down the program, it like doubles fragments and deletes some others, and it causes a lot of wonkiness. And it's not something you can see until you're watching it, and then all of a sudden the lips don't move, and the words are still going, and it's kind of hard to try to line it up. But I think I did an okay job. But it drives me absolutely crazy. It really does. It drives me absolutely crazy when the mouth movements don't match up with the words. I try. I just had to let the whole world see that before I went on. The things my chat talks about. I love it. I love it. What would I ever do without you guys? I have no idea. I'm so grateful that I was blessed enough to be in a position to find you guys. Yeah, it sucks that it took an SUV hitting me for it to happen, but I don't know that I would change it. Maybe. Nah, I'd still find a way to have met y'all.
All right, Stutsman County District Court is now in session this January 2nd, 2024. The time is now 3:07 p.m. My name is Nick Thornton. I'm a District Court Judge for the Southeast Judicial District, which includes Stutsman County. I am sitting in the Stutsman County Courtroom number 1. The door is propped open. The building is open. These are open and public proceedings. We are also live streaming this event on the Southeast Judicial District's live stream YouTube channel. Any member of the public can attend these proceedings either in person in the gallery in the Stutsman County Courtroom number 1, or by following along in the Southeast Judicial District's live stream YouTube channel. What we have on the calendar this afternoon are a number of initial appearances and bond appearances. First case the court is going to call for this 3 o'clock docket will be State of North Dakota versus Daryl Edward Hennings, file 47-2023 CR 125. Mr. Hennings appears by way of reliable electronic means from the Stutsman County Correctional Center without counsel. Who is taking this from the state? Mr. Gonzalez is appearing on behalf of the state here personally in the courtroom. Mr. Hennings, can you hear and see me okay?
Yes.
All right, sir, were you present in court when your rights were read to you earlier?
Yes, I was.
Do you understand your rights?
Yes, I do.
Do you have any questions about your rights, sir?
No, sir.
You're here for a post-judgment 24/7 allegation. The state alleges that on or about December 22, 2023, you were scheduled for a patch change-out, a drug patch change-out on the 24/7 sobriety program, sir. The state alleges that you did not appear for that change-out. Do you understand what's being alleged, sir?
Yes, Your Honor.
Before we move forward, we have to talk about Zoom and we have to talk about your right to counsel. Sir, you do have the right to be personally present in court with me and with the prosecutor and with your attorney if you desire. You can waive that right and we can conduct the hearing by reliable electronic means if you consent to do so. I'll make clear to you, sir, that we won't have any testimony, trial, or sentencing that occurs by reliable electronic means unless you specifically consent. The state consents and the court approves. Knowing all of that, sir, are you okay with conducting this hearing by reliable electronic means?
Yes, I am.
All right, the court will find a knowing, voluntary, and intelligent waiver of the right to be personally present in court and find that reliable electronic means is appropriate for today's hearing. Next issue, sir, you have the right to an attorney. I did mention that before, and it was mentioned in those rights that were played on that video. You have the right to hire a lawyer of your choosing. You have the right to apply for a public defender, and if you financially qualify for one, a public defender would be appointed for you.
No. I honestly think the infraction and charges happened far before that even. This whole docket aired on January 2nd. Every case, every hearing. I went back into the archive drive to find good cases for you guys.
Or you can choose to represent yourself. How would you like to proceed today?
I'll represent myself.
Has anyone threatened you, forced you, or coerced you, or in any way made any promises to you in order to get you to waive the right to an attorney?
No.
And you understand, sir, that by waiving your right to an attorney today, you can choose to apply for a public defender or hire a lawyer at any time while your case is still pending.
Yes, Your Honor.
But for today's purposes, you want to move forward right now without an attorney.
Yes, sir.
Okay. So again, I've read to you what the state's allegation against you is, essentially that you didn't show up shortly before Christmas for a patch change out. They issued a warrant on the day after Christmas on December 26th. A different judge issued that warrant. Looks like you were picked up. When were you picked up, sir?
I just turned myself in today.
All right, so today is now January 2nd, 2024. So we're talking about being off the patch for about a week. Is that right?
Yes, Your Honor. I still had the patch on when I got here.
So, okay. But you understand, I just wanted to make sure I understand when you got picked up or when you turned yourself in. So you were supposed to change it out on December 22, and you didn't change it out until now, essentially, right?
Yes, sir.
Do you admit to that allegation or do you deny the allegation that you were supposed to show up on December 22, 2023 and did not?
I admit it.
Okay, has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to admit to the allegation, sir?
No, Your Honor.
Mr. Gonzalez, if this defendant admits to this violation on this B misdemeanor DUI post-judgment 24/7 allegation. What are your thoughts on disposition?
Your Honor, looking at the record, it does appear that this is his first violation. The fact that he admitted it, giving him the first bite of the apple per se, I'd say just have him back on the 24/7 conditions originally as noted, and have no further sanctions beyond that.
All right, sir. Do you understand what the state's going to recommend if you admit to the allegation?
Yes, Your Honor.
And knowing what the state is going to recommend, it's what you want to do is to admit to the allegation and have me accept that and impose the sanction the state is asking for.
Yes, Your Honor.
Do you have anything else to tell me?
Just that I've been clean ever since they put the patch on me, and so I wasn't trying to get away with anything.
It's not that we don't believe you. It's just, I think it was Reagan that said trust but verify, right? Right? Most people in your position can't be trusted. So we always have to verify.
I just slipped my mind with Christmas and everything. I just forgot to come.
Okay. Well, sir, they're asking me to put you right back on the program. I want you to understand that ordinarily courts will do that once, and after that, they start imposing jail sanctions. You understand?
Yes, sir.
And so it's really important not only that you stay clean, but also that you're appearing for patch changeouts when you're supposed to.
Yes, sir.
All right. Anything else? You get the last word.
No, I'm good. No.
All right. The court is going to find a willful violation of the 24/7 program as a condition of probation. This is post-judgment. The court is going to, as a sanction, order the defendant to serve 1 day in jail. The defendant has served 1 day in jail and will be given credit for it, in addition to any credit that was originally provided in his judgment. The defendant's conditions of probation remain the same, so he is on the 24/7 program. He will need to have a clean patch applied to him right now. The 24/7 condition is still a condition of probation, and the defendant is required to comply with that program. Anything else for the state?
No, Your Honor.
Anything else for you, Mr. Hennings?
No, thank you, Your Honor.
All right, with that, we are adjourned in that matter. Thank you. Next case the court has on the docket, State of North Dakota versus Dustin Larry Severson, file 47, 2023 CR 163. Who's handling this for the state? Mr. Gonzalez? All right. So the state appears in person through Mr. Gonzalez as the assistant state's attorney. The defendant, Mr. Severson, appears personally by reliable electronic means from the Stutzman County Correctional Center without counsel. Mr. Severson, can you hear and see me okay?
Yes, sir.
All right, we're here for essentially the same thing as the last case, although slightly different in that this one has some positive results. But it is a post-judgment 24/7 allegation. Sir, were you present in court when your rights were read to you earlier?
Yes, sir.
Do you understand your rights?
Yes, I do.
Do you have any questions about your rights?
No, Your Honor.
All right, sir, with respect to your right to appear in person, you do have the right to appear in person with me, the prosecutor, and with your attorney if you so desire. We can conduct the hearing by reliable electronic means if you consent. I'll let you know that the state, we won't have any trial testimony, trial sentencing, or any of those types of things without your explicit permission, the state approving and the court approving, sir. Do you wish to have this hearing held by reliable electronic means?
Yes, sir.
All right, has anyone threatened you, forced you, or coerced you, or in any way made any promises to you in order to get you to waive your right to appear in person?
No.
Court will find a free, knowing, and voluntary waiver of the right to appear in person and conduct this hearing by reliable electronic means. Sir, you have the right to appear by an attorney or have an attorney help you with this case at any time and for any critical stage of the proceedings while this case is still pending. You were advised of your right to an attorney in that video earlier. And I'm telling you now, sir, you have the right to be represented at this hearing by an attorney of your choosing. If you choose to hire one, you can apply for a public defender. And if you financially qualify for one, the court would appoint one for you. Or you can choose to represent yourself as long as you do so knowingly, voluntarily, and intelligently. How would you like to proceed for today's purposes?
Today's purposes, I'd like to represent myself.
Has anyone threatened you, forced you, or coerced you, or in any way made any promises to you in order to get you to waive your right to an attorney?
No,
All right. And you watched the last one happen, so you kind of have an idea of how this is going to work, right?
yes, sir.
And you still want to move forward here without an attorney?
Yes, sir.
Okay. So there is an affidavit of probable cause in support of a 24/7 violation post-sentence in your case, and there's actually two of them. Both of them are dated today. The first relates to positive patches, positive for methamphetamine and amphetamines, with patches removed on December 12, 2023 and December 22, 2023. And then there was another allegation that you did not show up today between 8 and noon for your patch changeout, sir. So there are three allegations. It's a positive test on December 12, 2023, a positive test on December 22, 2023, and a no-show between the hours of 8 and noon today. Do you understand the allegations against you, sir?
Yes, I do, Your Honor.
And you have the right to admit or deny those allegations. With
I
respect,
admit them.
well, we'll take them one at a time. With respect to allegation one, that you had a positive methamphetamine and amphetamine test on the patch removed December 12, 2023. Do you admit or deny that allegation?
I admit.
And you've got allegation number two, that you tested positive for methamphetamine and amphetamine on the test for the patch removed on December 22, 2023. To that allegation, do you admit or deny?
I admit.
And then allegation three is that you didn't show up between the hours of 8 and noon today for a patch changeout.
Yes, that was a mix of dates.
Okay? And so were
I
you
admit.
you admit or deny that, and you admit?
I admit.
What time did you get picked up, sir?
I turned myself in.
When?
You know, both of these guys, they're very humbly taking their lumps. I think that's going to bode well in their favor.
About 2 o'clock when I came in.
All right.
I had the dates mixed up. I thought it was tomorrow when I got my patch changed up.
All right. Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to admit to the allegations today?
No, sir.
Mr. Gonzalez, what are your thoughts on judgment disposition here? Looks like a pair of Class C felonies, supervised probation, deemed a misdemeanor, post
I
judgment.
did.
Hold on.
Okay.
Mr. Gonzalez, your thoughts on disposition?
Yes, Your Honor. So there's two things that concern me greatly. One, that in reading the affidavit, it does state that this is his 5th and 6th positive patch removal since being on the 24/7 program, as well as the results of the patch from both the December 12th and the December 22nd results indicate a steady climb while being on the patch. Now, I'm quite familiar with the drug patch. I understand that if there's high enough dosages found in one test result, we should be seeing some kind of downward deviation in the next 10 days, the next 20 days, so on and so forth. However, we're not seeing that here. We're seeing a steady uptick. It's my belief that he's still been using while on the 24/7 program. And being that this is his multiple violations of said program, I'm going to be asking for 30 days in jail, Your Honor. It's clearly a willful violation by the defendant while he's on the program, and it does look as if the results are indicating that there's still continual usage.
Okay. Sir, you know what the state is asking for. Are you still asking the court to accept your admissions to the allegations against you?
Yes, Your Honor.
Okay, and you understand the state's they're asking for 30 days in jail.
Okay, but I did sign up for inpatient treatment in Canby, North Dakota. And they do have a bed open for me.
At Hartview?
Yes.
And when do you expect to go to Hartview?
As soon as my probation officer gives a consent of information,
Who's your probation officer?
Corey Copeland.
Mr. Gonzalez, have you consulted with probation on what they intend to do in light of the fact that the defendant is on supervised probation?
No, Your Honor, I just got this file quite recently before coming to these proceedings. Had I have any information from the probation office, if they do have verification of a bed waiting for him, that would change my recommendation. But as it stands right now, I will be still asking for the 30 days.
All right.
Okay. I'm assuming you're meaning the prosecutor, right? That is where was it which character was it that you think said that? About 30 seconds. I don't have that ability. Okay, hold on. I'm at 16:07. Make it 2 minutes. Everybody blame Mortimer for this. I don't know what part you misheard. The judge. Oh my. Okay. Well, was it before the prosecutor spoke? Okay, we're just gonna randomly start. Supervised probation. Thank you, Nana Laura. But let's see if anyone else hears what Mortimer Duke heard. Oh my.
Dates.
Okay. And so were
I
you
admit.
you admit or deny that and you admit?
I admit.
What time did you get picked up, sir?
I turned myself in.
When?
About 2 o'clock when I came in.
All right.
I had the dates mixed up. I thought it was tomorrow when I got my patch changed up.
All right. Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to admit to the allegations today?
No, sir.
Mr. Gonzalez, what are your thoughts on judgment disposition here? Looks like a pair of Class C felonies.
P.T. Barnes has a whole new role.
Supervised probation deemed a misdemeanor.
But
Post-judgment.
I did.
Hold on.
Okay.
Mr. Gonzalez, your thoughts on disposition?
Yes, Your Honor. So there's two things that concern me greatly. One, that in reading the affidavit, it does state that this is his 5th and 6th positive patch removal since being on the 24/7 program, as well as the results of the patch from both the December 12th and the December 22nd results indicate a steady climb while being on the patch. Now, I'm quite familiar with the drug patch. I understand that if there's high enough dosages found in one test result, we should be seeing some kind of downward deviation in the next 10 days, the next 20 days, so on and so forth. However, we're not seeing that here. We're seeing a steady uptick. It's my belief that he's still been using while on the 24/7 program, and being that this is his multiple violations of said program, I'm going to be asking for 30 days in jail, Your Honor. It's clearly a willful violation by the defendant while he's on the program, and it does look as if the results are indicating that there's still continual usage.
Okay. Sir, you know what the state is asking for. Are you still asking the court to accept your admissions to the allegations against you?
Yes, Your Honor.
Okay, and you understand the state's they're asking for 30 days in jail.
Okay, but I did sign up for inpatient treatment in Camden, North Dakota. And they do have a bed open for me.
At Heartview?
Yes.
And when do you expect to go to Heartview?
As soon as my probation officer gives a consent of information,
Who's your probation officer?
Corey Copeland.
Mr. Gonzalez, have you consulted with probation on what they intend to do in light of the fact that the defendant is on supervised probation?
No, Your Honor, I just got this file quite recently before coming to these proceedings. Had I have any information from the probation office, if they do have verification of a bed waiting for him, that would change my recommendation.
Hey, you! We were talking about you. Please tell us all that you're okay with the volcanic activity that's going on in the Philippines right now. Manny posted it in the Discord and my heart sank. So I really hope everything's okay with you. I'm so glad to see you. That takes a huge, huge relief. Seriously. Oh, hey, I used to get those all the time. No, you won't. Absolutely not. I forbid it.
Gives a consent of information,
Who's your probation officer?
Corey Copeland.
Mr. Gonzalez, have you consulted with probation on what they intend to do in light of the fact that the defendant is on supervised probation?
No, Your Honor, I just got this file quite recently before coming to these proceedings. Had I have any information from the probation office, if they do have verification of a bed waiting for him, that would change my recommendation. But as it stands right now, I would be still asking for the 30 days.
All right. When's my next Stutzman Master? What time? Here's what I'm going to do. I'm going to accept the defendant's admissions to allegations 1, 2, and 3. Court's going to find them freely, knowingly, and voluntarily and intelligently entered. Court is going to defer imposing any punishment on these matters. At this time, I'm going to set essentially a sanctions hearing or a punishment hearing for January 29, 2024 at 10:30 a.m. The idea here, Mr. Gonzalez, is I plan on treating this just like a sentencing hearing, but I'd like input from probation on what they intend to do because he's on supervised probation at the same time. And in the meantime, sir, if there's any documentation you can get from your probation officer concerning inpatient treatment at Heartview, that might significantly change the state's position here. But for this moment, I'm going to accept the admissions. I'm going to release you on the same conditions that were imposed previously as a condition of judgment and as conditions of probation, sir. You're still on supervised probation. You're still on the 24/7 program.
Yes, sir.
You're going to have another hearing and that hearing will happen at the end of the month, January 29, 2024, in the Stutsman County Courthouse, courtroom number 1 at 10:30 a.m. before me. If you are at the time in Hartview, we can change the hearing to a Zoom hearing or a remote hearing. But if not, I'm going to want you personally present in court, because if nothing changes, the state is going to be asking for jail time and you need to be personally present. I want you to understand that if you're not in a treatment facility, I want you here. And
Yes, sir.
if you're not in a treatment facility, you should pack a toothbrush and be prepared to go to jail if that's what's going to happen. Okay?
Yes, sir.
So that'll be the court's plan today. I'm going to simply release you on the same conditions imposed before. However, I want you to understand there will be a further sanctions or punishment hearing, sentencing hearing, January 29, 2024, 10:30 a.m. All right?
Yes, sir.
Anything else from the state?
No, Your Honor.
All right, that adjourns the matter at this time. Thank you.
Thank you, Your Honor.
Next case the court's going to take up will be State of North Dakota versus Adnan Muse, file 47-2024 CR2.
Good afternoon, Your Honor.
Good afternoon. Who's handling this case? Ms. Depute? Ms. Depute appears personally for the state. We are again in Stutsman County Courtroom number 1. The door is propped open. The building is open. These are open and public proceedings. We're here for an initial appearance. Mr. Muse, can you hear and see me okay?
Yes, sir, I can.
All right. Were you present in court when your rights were read to you earlier?
Yes, sir.
Do you understand your rights?
Yes, sir.
Do you have any questions about your rights?
Just one. If I choose to represent myself today, in future court court dates, will I get a court-appointed lawyer?
So, yes. Well, I'm going to be clear here. Maybe. So, if you choose to represent yourself, and we're going to get to this in just a moment, for today's purposes, that's not a permanent decision. You can always change your mind and hire a lawyer of your choosing, or you can apply for a public defender. If you financially qualify for a public defender would be appointed for you. If you don't qualify for a public defender financially because you make too much money, for instance, that means that you can still hire a lawyer at a later date, or you can choose to continue to represent yourself. But those are your three options. So when you ask the question, if you choose to represent yourself today, will you get a public defender later? The answer is yes, if you financially qualify. No, if you don't financially qualify. You understand that?
Yes, I do, sir.
All right. And you still have to apply for a public defender. You can't just say, I want one. You actually need to fill out a form, and then the court will review the form to determine whether or not you make enough money to hire a lawyer of your choosing, or if you don't make enough money, then the court would appoint a public defender for you. Okay?
All right.
All right. So circling back to the first question, I asked you, do you understand your rights and do you have any questions about them? Other than the attorney question that we just addressed, do you have any other questions about your rights, sir?
No, sir, I don't.
All right. You do have the right to be personally present in court with me and not to conduct this hearing by reliable electronic means, or we can do it just the way that we are by video here or reliable electronic means if you consent to that. Are you okay with this court holding the hearing by reliable electronic means?
Yes, sir, I am.
All right. Has anyone threatened you, forced you, or coerced you in any way, made any promises to you in order to get you to waive your right to be personally present?
No, sir.
All right. So the court will find a knowing, voluntary, and intelligent waiver of the right to be personally present and consent to appear by reliable electronic means. And sir, we did just talk about the attorney question. You do have the right to an attorney to represent you at any critical stage of the proceedings, including the initial appearance and setting a bail. You have the right to hire a lawyer of your choosing. You have the right to represent yourself, or you have the right to apply for a public defender. And if you financially qualify for one, a public defender would be appointed to you. Do you understand your right to an attorney?
Yes, sir, I do.
And for today's purposes, Do you wish to represent yourself?
Yes, Your Honor, I do.
And do you understand, sir, that at any time while your case is still pending, you can apply for a public defender or you can choose to hire a lawyer of your choosing? So today's decision is not permanent. You can change your mind and apply for a public defender or change your mind and hire a lawyer at a later date if you want.
Yes, I do.
All right, the court will find a knowing, voluntary, and intelligent waiver of the right to counsel for today's purposes. So moving forward here, sir, have you received a copy of the charging document in your case? Actually, there are two of them.
No, I haven't.
All right, what I'm going to do, sir, is I'm going to share my video screen, so you're not going to see me. You're going to see a copy of the charging document, at least the first one. Sir, can you see that?
Yes, sir, I can.
Is your name spelled correctly on that document right here where my mouse is moving?
Yes, sir.
Is your address correct on that document right here?
Yes, sir, that's correct.
And what is your current phone number, sir? 6561, you say?
Yes, sir. And what is this charge?
So we're going to get to that in just a moment. Is your date of birth correct? 4/16/1999.
Yes, sir.
All right. So you have the right to have this document read to you in its entirety, or I can summarize it for you. Are you okay with the court summarizing this document for you?
Yeah, yes, sir.
The state alleges that on New Year's Eve, or on December 31st, 2023, in Jamestown, North Dakota, in Stutsman County, near highway mile marker 266 on Highway 281, so this is Business Loop, in Jamestown, that you committed the offense of driving under the influence of a controlled substance, or DUI drugs. As charged, sir, that is a Class B misdemeanor. It carries with it a maximum penalty of 30 days in jail, a fine of $1,500 or both.
Okay.
It carries with it a minimum mandatory penalty of a fine of, is this a first offense, Mr. Gonzalez?
It's the first offense, Your Honor.
Ms. Depute, I'm sorry, thank you. So with a first offense DUI, it carries with it a maximum penalty, or a minimum mandatory penalty of a $500 fine, court fees totaling $250, and a chemical dependency evaluation and follow through with the licensed addiction counselor. So maximum penalty, 30 days in jail, a fine of up to $1,500, minimum mandatory penalties of $500 in fines, expected court fees totaling $250. That's $125 administrative fee, $100 facility improvement fee, and a $25 victim witness fee. That's where I get the $250. And then a chemical dependency assessment by a licensed addiction counselor. All right. If your conduct causes financial or pecuniary harm to another individual, this can result in an order from the court for restitution. If you're not a U.S. citizen, this offense can implicate adverse immigration consequences for you that were explained before in that video. Do you understand that, sir?
Yes, I do, sir.
All right. So do you understand the nature of this charge, the maximum penalties, the minimum mandatory penalties, the court's ability to impose court fees, the court's ability to impose restitution, and the immigration consequences of the offense?
Yes, sir.
And the court is going to ask you for a plea of guilty or not guilty. If you plead guilty, there won't be any trial of any kind. You'd be waiving all of the rights that were explained to you before, and we would move forward with sentencing. If you plead not guilty, we will set your bail and schedule further proceedings for a later time. Do you understand what your options are? Guilty or not guilty?
Yes, sir. I plead not guilty, sir.
Not guilty plea will be entered for the record on this count. Moving to the next count, sir. There is another citation filed, or a uniform complaint and summons. Can you see this document?
Mm-hmm.
That's a yes?
Yes, I see it, sir.
All right. The reason why I asked you that to confirm with a yes or no, sir, is we're trying to make a record, and things like mm-hms and uh-hs don't really.
Sorry.
Yep, that's
Yeah.
why I asked you. So I wasn't trying to get down on you. It was just I want to make sure I have a clear record that you say
Yeah,
you.
I apologize.
Okay.
I apologize about that, sir. Yes, I
With
do
you-
see it. I do see the DUI refusal first off.
Okay. And so on this one, is your name, date of birth, and address all correct on this document?
Yes, sir.
And you do have the right to have this document read to you in its entirety, or I can summarize it for you just as I did the other one. Are you okay with the court summarizing this document?
Yeah, yes, sir. I'm all right with the court summarizing the document.
All right. So the state alleges that on or about the same date, December 31st, 2023, in Stutzman County, North Dakota, particularly on Highway 281, mile marker 266 and Business Loop in Jamestown, North Dakota, that you committed the misdemeanor, Class B misdemeanor level offense, DUI refusal first offense. This again is a Class B misdemeanor. It carries with it a maximum possible penalty of 30 days in jail, a fine of $1,500 or both. Associated court costs $250. Same minimum mandatory penalty of $500 in terms of fines, and a chemical dependency evaluation from a licensed addiction counselor. Do you understand the nature of this charge, sir?
Yes, sir.
Do you understand the maximum penalties, the minimum mandatory penalties, the associated court fees, the court's ability to impose restitution, and the immigration consequences associated with this offense?
Yes, sir.
All right. And to this offense, do you plead guilty or not guilty, sir?
Not guilty, sir.
Not guilty plea will be entered for the record. Ms. Depute, thoughts on bail?
Yes, the state is asking for $15,000 or 10%. In this case, I believe the defendant is either a flight risk or no appearance risk. He has 3 pending warrants out of Minnesota, particularly for case 73 CR 198282, 27 CR 2223 319, and 27 CR 23 11 37 All of these warrants were issued for failures to appear on different dates. One of them, the first case, a failure to appear in November 28th, 2022. The second case, a failure to appear on January 11th, 2023. And the third case, a failure to appear on June 26th, 2023. In addition, this defendant has already been subject to extradition to Hennepin County out of this state in case 47, 2023, CR 25. He does have an outstanding warrant out of this state. However, that was not for failure to appear. That was a warrant issued upon a summons and or issued upon a criminal information, but notwithstanding the fact that the defendant has 3 cases that have been stalled for anywhere from 3 to 1 year on account of his failure to appear in his outstanding.
This dude is the definition of flight risk.
Warrants, and the fact that there's nothing to suggest the defendant has any long-term residency or other ties to his community causes me to believe that having a substantial bond amount would be reflective of the concern for future appearances.
Are the warrants out of Minnesota felony level warrants?
Some are, some are not. So one is for possession of oxycodone, 5th degree felony. There's 2 misdemeanor thefts of property. There is liquor consumption by a person under 21, and then trespass. And I look quickly here whether that's a felony or misdemeanor level. He also has previous convictions out of Minnesota, possession of a pistol without a permit, and out of this state has a conviction of criminal mischief.
Your Honor, if I may.
I'll give you a second to speak in just a minute. Hold on. Anything else with respect to your bail recommendation, Ms. Depute?
No, Your Honor.
All right, Mr. Muse, am I pronouncing that correctly? Is it Muse?
It's Muse.
Muse, okay. Mr. Muse, What's your position on bail?
Your Honor, I won't be able to pay bail because I don't have no money at all, you know? And I have interviews coming up all this week and next week as well for McDonald's, Comfort Inn. I'm finally getting the opportunity to get a job, and many things are looking up and up for me. The only reason I haven't never showed up to those other court days is because I just simply didn't know about it. And if I did know about it, I would have been there. And now that I do stay in this town, I do stay, that is my address on the paper. I do stay within this town. That's the only place I had. This whole time I've been homeless when dealing with these other things. Now I got a place of residence. I can show up to court, Your Honor, and I'm just trying to be out there working hard instead of just being here sitting and looking at a wall, you know? I will show up to court, Your Honor.
Give me just a moment here, please. All right. The court starts with the constitutional provisions that are applicable to bail. Article 1, Section 11 of the North Dakota State Constitution indicates that all defendants are bailable upon sufficient sureties. The court takes that into consideration in conjunction with North Dakota Rule of Criminal Procedure 46. Subpart A of that rule creates a presumption of release upon one's personal recognizance or unsecured appearance bond unless the court has sufficient reason to believe or that the defendant might not appear for court. That in this circumstance, in light of the pending warrants out of Minnesota and out of North Dakota, the court does have sufficient information here to believe that the defendant will not appear, not by any fault of the defendant, but simply because as soon as these other jurisdictions find that Mr. Musse is currently present in Stutsman County, they will initiate extradition proceedings, and the court will simply lose jurisdiction if bail is set lower than what the court intends to set bail at here.
Oh, Judge, you are far too kind. Not by his own. Yeah. No. He would absolutely just abscond and not give two flips. Yeah. If he's ducked out of Minnesota for this long, he surely will do it to you.
So the court does have sufficient information to overcome the presumption of release upon personal recognizance, which is contained in Rule 46A. The court believes that a cash or, in the alternative, surety bond appearance is sufficient to require the defendant to appear in these cases. The court notes these are Class B misdemeanor level offenses. The maximum penalty is 30 days on these offenses, and ordinarily cases run or charges in the same file run concurrent unless there's a really compelling reason to continue them consecutively. So the court notes the clock is ticking here for the maximum penalty for these types of offenses. Nevertheless, the court does have sufficient concerns that the defendant simply won't appear because he'll be in custody in a different location if the court sets bail at a very low amount or an amount the defendant can make. All that means is not that the defendant would be released from custody, but simply that he would be transferred from this court's custody to another court's custody to resolve those matters in Minnesota or to resolve the matters in other jurisdictions in North Dakota. Bail will be set in the amount of $5,000 cash, or in the alternative at the defendant's option, $15,000 corporate surety appearance bond. Additional conditions of release: you shall not violate the laws of any city, county. I'm talking here now. You shall not violate the laws of any city, county, state, or nation. You shall be employed, actively seeking employment, or pursuing a course of study. You shall not leave the state of North Dakota without the advanced express permission of the court. You shall notify the court of any change of address, employment, phone number, or email. You shall not possess or consume any alcoholic beverages or controlled substances except as authorized by a licensed physician. You shall undergo reasonable medical or other examination or testing to determine your compliance with that requirement. Before release, you shall sign a promise to appear in waiver of extradition. You shall personally appear for all scheduled court hearings and appearances in this matter unless specifically excused by the court or by a proper waiver of appearance filed by your attorney. Your next court date, sir, is April 24, 2024 at 9 a.m. at the Stutsman County Courthouse, Jamestown, North Dakota. Sir, do you understand the conditions of bail as I've set them?
No, I don't understand. I don't understand. How can I pay bail, sir? Especially in the amount of $5,000. It doesn't make sense to me.
I understand it might not make sense to you, but that's the court's order.
And these other places are non-extraditable. I was already here last time I was here for a whole week, just for extraditable. When I signed the extraditable places, all these other places said they don't want to extradite me. She's bringing up a case from 2017 that I got taken care of in Hennepin. I don't see what that pertains to in 2024 January in Jamestown. She's bringing up a charge that I've already dealt with. Sir, this just seems unfair because I have all these interviews, all these job opportunities this week, but you guys are telling me to pay $5,000 bail. There's a guy, no offense to you guys, by the way, but there's a guy that literally ever since he got on the drug court, he's been doing nothing but up. And the guy over there, he was recommended for 30 days in jail, but I can't go home and try to get a job. It just doesn't seem fair. It just seems as if everywhere I go, it's just like I've been beaten down, and then it doesn't really seem fair to me. But what can I do about it? It's just it seems like you've made a decision, and thank you, Your Honor. Thank you, Mrs. Prosecutor.
Sir, you do have the right to have bail reviewed if you remain in custody for 48 hours following today's hearing. So you have the right to have bail.
But what you don't understand, sir, what you're not understanding is this is my first offense. This is my first offense to you guys. She's using warrants that I never knew about.
It's my first offense to you guys. Your Honor, just forget about the other state, the other cases. They don't matter. This is my first offense to you guys.
As a way to keep me in here, that doesn't make sense to me. It doesn't make sense. Like so far, it seems like you guys have been nothing but nice to everybody, but except for me. And then, sir, before I get pissed off even more, like I'd rather just you've made your decision, correct? The $5,000 bail.
Your bail is set in the alternative, either $5,000 or a $15,000 corporate surety bond. And the reason is...
What's that? What does that mean?
You can get a bail bondsman who, if he makes a promise to pay $15,000 if you don't show up, you can be released on that bail bond, sir. I've made my decision. You have the right to have your bail. So stop talking over me. You have the right to have bail reviewed if you remain in custody for 48 hours. I understand this bail appears to be high, but the reason is you have these pending warrants. If the state finds out that those warrants, excuse me, sir, did you just flip me off?
No, I didn't flip you off. I was saying I'm going like this.
Okay.
This is driving
Well,
me
I want to
crazy.
make
I
sure.
want to flick you off. I'm not that disrespectful, sir.
Well,
my mama raised me right.
I'm glad that she raised you right, sir.
But
I just saw a hand gesture and I wasn't sure.
I go,
Sir?
okay, it's all right, sir. It's all right.
I've
So
made
I'm
my
sorry.
decision.
I'm sorry that I'm not just happy about it. I'm sorry that I'm not just happy about it. But to me, it doesn't seem fair, sir. It really, honestly, doesn't seem fair at all.
I understand how you feel about it, sir. I'm not treating you with any disrespect. I've been nothing but nice to you. It's my job to make decisions that sometimes are hard. I don't like this decision either, but I also don't want you to disappear because you end up back in Minnesota.
Why would I disappear, sir? I stay
Because
here.
you'd be
I live in Jamestown. I am a resident of Jamestown, North Dakota, Your Honor.
I understand, sir, but with the pending warrants out of Minnesota, that's the court's concern. So if those warrants turn out to be non-extraditable.
What is the concern? What is the
stop
court's concern?
talking now. So, Ms. Depute, if those warrants turn out to be non-extraditable, I would expect the state to inform the court that those warrants are non-extraditable, and that very well might significantly change what I do for bail.
I understand, Your Honor.
All right. Did you just understand that, sir? I just told the state that I want them to find out if these are non-extraditable warrants, and if they're non-extraditable, that will change how I view the case. But right now, I just don't want you to end up in Minnesota's custody, because then I can't get you back to court. Okay?
Okay, thank you.
So
Thank you,
that's
sir.
that's what I asked the state to do, but I've made my decision for today, because right now it looks like Minnesota will take you, and it's not your fault. It just, that's how it is. So
Sir,
I want to make sure you don't disappear.
Your Honor, there are non-extraditable 100% because I've been here. This gentleman here, last time I was here for a week, and they were waiting for extraditable just for Minnesota to say, we don't want him. It's not extraditable. We don't want him.
You know, that's not exactly something you flex about. It's not a brag, sir. Some things you can keep to yourself. This guy right here, this jailer, I know him. He's my bro. He's my homie. I was just here a week ago. Dude and I, we go way back.
You know, just for Minnesota to say that, sir, I've dealt with this. I've been trying to get that figured out. I've been trying to get some money so I could pay the bill and you get a court date set up and everything, but I can't do that without a job, without me being out there and getting a job and working hard for my money. Sir, you see where I'm being placed between a rock and a hard place, sir? They are unextraditable. And when can we find out that, how fast can you guys find out that they're non-extraditable so I can make these interviews, sir? Please, please try to work with me so I could be let out today. So I can, because I know it's fast. We can find this out fast, quite fast, right? Because I was here last time. Yeah?
Sir, that's not something that I can do today. So at this point, I've made my decision. You can have bail reviewed within 48 hours. Mr. Pute's going to be working hard to determine whether these are compatible or not. So that concludes the matter. Go with the sheriff. Thank you.
All right, am I good to go?
You are. Have a good day, sir. Next case the court's going to take up will be State of North Dakota versus Kelly Lynn Andrews. Is this you, Mr. Gonzalez?
It is, Your Honor.
Mr. Gonzalez appears personally in court for the state. Miss Andrews appears by reliable electronic means. Good afternoon, ma'am. Can you hear and see me okay?
Yes, Your Honor. Sorry, I'm crying because that just scared the crap out of me. I don't want you to be in a bad mood because I don't have bail money.
Yeah. I'm not in a bad mood. So here's where we're at. Can you hear and see me okay?
Yes, Your Honor.
Were you present in court when your rights were read to you earlier?
Yes, Your Honor.
Do you understand your rights?
Yes, Your Honor.
Do you have any questions about your rights, Miss Andrews?
No, Your Honor.
You do have the right to be present in court with me personally and with the prosecutor and with your attorney. You can waive that right and we can have the hearing by reliable electronic means if you consent. Do you consent to the court holding this hearing by reliable electronic means? All right. Has anyone threatened you, forced you, or coerced you, or in any way made any promises to you in order to get you to waive your right to appear in person and to have this hearing by reliable electronic means?
No, Your Honor.
All right, the court will find a knowing, voluntary, and intelligent waiver of the right to appear in person and consent to conducting the hearing by reliable electronic means. Ma'am, you mentioned that you were present during your rights video. You have the right to an attorney that you hire. You have the right to apply for a public defender, or you have the right to represent yourself. If you choose to represent yourself, I want you to understand that that decision isn't necessarily a permanent decision. You can apply for a public defender or hire a lawyer at a later time if you so choose. For today's purposes, how would you like to proceed with respect to your right to an attorney?
I applied for a court appointed.
Have you already done so? Have you already applied for a public defender?
Yes, I just filled out the paperwork, Your Honor.
All right, tell me a little bit about how much money you make per month. What are you doing for work?
I work at North Casey's.
Uh-huh.
I actually unfortunately missed today and yesterday for being here, but I work 40 hours a week
And
normally.
How much money do you make
14.
per hour?
$14. I work 32 to 40 hours a week. And my rent is $9.50 a month.
But that's not actually hold on, let me talk to this guy, bro. I'm frustrated. I'm mute, bro. I'm here, bro.
Who lives with you at your home?
My boyfriend, and my
Anyone
dog
else?
and cat. No, my dog and cat.
Is your boyfriend working?
Yes. We split our bills down the middle.
I actually kind of like this gal. She's very respectful. And I can understand her being terrified that the judge might take out frustration from the previous jerkhole on her, but that's not this judge. She at least has a job. She's got a dog and a cat. She's, she's trying.
All right. So ma'am, I was doing a little bit of math. That's why I'm looking down and I'm typing on my phone here with the calculator function. It looks like at $14 an hour for 32 hours a week times 4 weeks a month, and $14 an hour by 40 hours a week times 4 weeks per month. That ranges between $1,792 and $2,240 per month.
Apparently, I don't know how to do math then. I was trying to do it in my head or on paper.
Well, I just did it for you, so
I
if
thought
you're
I
only
came up with
working-
1,400 a month.
okay, so when I do
Sorry.
$14 an hour times 32 hours a week, I come up with $448 a week.
Yep.
If I multiply that by 4, I get $1,792.
Yep, my math sucks. I'm sorry, Your Honor.
And if you do $14 an hour times 40 hours a week, that comes up to $560 a week. If I multiply that by 4, I come up with 2240. All right.
Okay.
And so when I look at the income threshold, you are close to that income threshold, but you are over it.
Uh-oh.
So,
I'm sorry to interrupt, Your Honor. I don't know if I was reading it right, but there's not really a place on there to say what my bills are a month. Because
Yeah, I
I
know.
have a truck payment, my car insurance alone is $200 a month. And then my truck payment's also $200 a month, and then half of $950 is, yeah, I'm kind of broke.
I understand the threshold that they set for public defenders is 125% of the federal poverty level. And so that's why these numbers are what they are. That number might change in 2024, but the only numbers I have are the 2023 numbers, and they set that monthly gross income threshold at 1519 in 2054. And I think that you make more than the 1519 if you're a 1-person household size. For a 2-person household size, I'd have to factor in his income as well.
He makes more than I do, but they take a lot of child support from him.
I understand. So what I'm saying is you presumptively don't qualify. Now,
Okay.
separate and apart from, so that means today we're going to move forward with you representing yourself, ma'am, or you can hire a
Okay.
lawyer of your choosing. If you are unable to hire a lawyer later, you can always reapply, and you can
Okay.
provide the court with proof that you've been trying to hire a lawyer and financially can't find any lawyer that will take your case. The court can make exceptions to those guidelines. Those guidelines are guidelines. They're not mandatory requirements. You're very close to the threshold, but you exceed it. And so what I want you to
Yes,
understand is I'm going to need some documentation if I'm going to appoint you a public defender. That is just something that you can't do right now. So, I mean, normally I would require you to go to 5 different lawyers and ask them to quote you a fee for your case and explain how you just financially can't do that with your bills. So when I make a decision on whether or not I'm going to deviate from the guidelines, I have some background and some proof that I can send to the commission to support my decision. Do you understand that, ma'am?
yes, Your Honor.
Okay, so for today's purposes, I'm going to deny your request for a public defender because you presumptively make more than what the guidelines allow. And so we'll move forward here. Ma'am, have you received a copy of the charging document in your case?
Yes, Your Honor.
It at the very top would say North Dakota Uniform Complaint and Summons.
Report and notice under chapter 39-20.
Yeah, the report and notice is different. You should have gotten 2 documents. That was one of them. And then you should have gotten another document that's about a half a page.
I have this one, but this one says just a moving violation, $20.
So it should look like that, but it'll say Uniform Complaint and Summons. Here's what I'm going to do. I'm just going to share my screen so you'll be able to see what I'm looking at.
Thank you, Your Honor.
Can you see that document now?
Yes, Your Honor.
All right. You have the right to have this document read to you in its entirety, or I can summarize it for you. Are you okay with the court summarizing this document for you?
Yes, Your Honor.
All right. So is your name spelled correctly on here? Kelly Lynn with an E, Andrews, ordinary spelling?
Correct.
Your date of birth, 6/21/1976?
Correct.
And
My
your
address is wrong.
What is your current address, ma'am?
Everything is correct, but it's apartment B as in boy, not 5.
Apartment B is in boy, not 5.
Correct.
Jamestown, North Dakota, 58401.
Correct.
All right, and your phone number is correct?
Correct.
All right. So, and just to confirm, I forgot, you agreed to have me summarize the document?
Correct.
The state alleges on
Thank
January 1, 2024, so New Year's Day, very early, about 12:40 a.m. on New Year's Day in Jamestown, North Dakota, highway mile marker 67 on Highway 281 in Stutsman County, North Dakota, you committed the offense of driving under the influence with an alcohol concentration of 0.08% or greater. First offense. Mr. Gonzalez, is this an aggravated first offense or a standard first offense?
Standard first offense, Your Honor.
All right, thank you. Do you understand the nature of the offense as charged, DUI at a 0.08 or greater?
Yes, Your Honor.
As charged, ma'am, this is a Class B misdemeanor. It carries with it a maximum possible penalty of up to 30 days in jail, a $1,500 fine, or both. It carries with it minimum mandatory penalties. The minimum mandatory penalties applicable in the court case are a $500 fine, associated court fees of $250, that's a $125 administrative fee, a $100 facility improvement fee, and a $25 victim witness fee, and addiction evaluation by a licensed addiction evaluator. So minimum mandatory penalty, again, $500 fine, $250 in court fees, and a chemical dependency evaluation follow through with licensed addiction counselor.
Yes, Your Honor.
If you were convicted of this offense and your conduct caused any financial harm to someone else, the court can order restitution. If you're not a U.S. citizen, this can have adverse immigration consequences. Do you understand all of that as well?
Yes, Your Honor.
Because this is a misdemeanor, I'm going to ask you for your plea. If you plead guilty, you'll be waiving all the rights to a trial and all the rights that were previously read to you. We'd have no trial of any kind. We'd move to sentencing. And that would be how we would take care of the matter. It would be resolved today. If you choose to plead not guilty, the court will enter that not guilty plea for the record. The court will schedule further proceedings and set your bail. Do you understand what your options are if you plead guilty or not guilty?
Yes, Your Honor.
And how would you like to plead, ma'am? Guilty or not guilty?
Not guilty.
Not guilty plea will be entered for the record. Mr. Gonzalez, thoughts on bail?
Thank you, Your Honor. So looking at her criminal history, at least in concerns to any DUI convictions, there are none. I do not see any failures to appear, no open warrants out of any county or any state concerning the defendant. She does have a rather lengthy drug history, but that is no concern, at least to the state when it comes to these matters right now. I'm just going to be asking for a unsecured bond of $750. Given the fact that, again, I don't have any failures to appear in her criminal history. I don't have any other county or state looking for her for any warrants or any of that matter, and that this is a first offense. I'm going to just be asking for $750 unsecured.
All right, ma'am, anything that you want to tell me before I impose bail?
I don't have that much money.
Ma'am, stop,
Yes.
I think,
2
stop.
days of work.
Ma'am, I think you misunderstood what the state is asking for. Okay? So what they're asking for is you to promise that if you don't show up when you're supposed to show up, then you would pay $750.
Oh,
You don't-
yes,
they're
yes,
not
Your
asking,
Honor.
they're not asking for any cash right now.
Okay, yes, thank you. Sorry, I was confused.
Well, and that's why I clarified that. Do you understand what the state is asking for now?
Yes, Your Honor.
Do you have any questions about that?
No, Your Honor.
Is that what you want me to do?
Yes, please.
All right.
I would like to
bail-
go back to work.
All right.
Holy cows, this lady loves her job.
So here's what I'm going to do. I'm going to adopt the state's bail recommendation. Bail will be set at $750 unsecured appearance bond, which means again, ma'am, that you pay nothing to get out, but you'll have to sign a promise to appear in order to get out, saying that if
Yes,
you don't
thank you.
show up when you're supposed to, then you'll pay $750. Additional
Yes, Your
conditions of release: you shall not violate any laws of any city, county, state, or nation. You shall not leave the state of North Dakota without the advance express permission of the court. You shall notify the court of any change of address, employment, phone number, or email. You shall not consume any alcoholic beverages or controlled substances except as authorized by a licensed physician. You shall undergo reasonable medical or other examination or testing to determine your compliance with the requirement. Before your release, you shall sign a promise to appear and waiver of extradition. You shall personally appear for all scheduled court hearings and appearances in this matter unless excused by the court or by proper waiver of appearance filed by your attorney. Your next court date, ma'am, is April 17, 2024 at 9 a.m. at the Stutsman County Courthouse, Jamestown, North Dakota. That date again, April 17, 2024, 9 a.m. at the Stutsman County Courthouse. Do you
May I ask a
understand?
question, Your Honor?
You may.
Sorry. Well, somebody told me last night that it was gonna be January 29th. I had to go to court.
Nope.
I just want to make sure I do it right.
Well, I want to make sure because you mentioned a report and notice that you understand the difference. All right. So in terms of the court proceedings, there might be a proposed scheduling order in this case that has certain dates, including January 24 for a preliminary hearing. Those don't
Okay.
apply in your case because those only apply to felony level offenses. This is not a felony level offense. Your next court date is April 17, 2024 at 9 a.m. You mentioned that other
Right.
form. That other form applies to your driving privileges. That
Okay.
form, understand that if you don't request a hearing within 10 days of the driving conduct, that form means that the Department of Corrections intends to take your driving privileges. If you
Okay,
request
so
a
how
hearing,
do I do that?
I can't give you legal
Sorry.
advice other than to tell you that's what that form is. So if you're convicted of this offense, there are adverse license consequences. If you don't respond to that report and notice, there are adverse license consequences. You have 10 days from the driving conduct in order to request a hearing. If not, you've defaulted on the implied consent hearing, and they will take action on your driving privileges, assuming that that form is filled out correctly. If you have any
Okay.
questions about your driving privileges, you must contact an attorney licensed to practice law in North Dakota, talk with them about how to proceed with both of the criminal action and the administrative driver's license consequences. You're going to want to check that out with an attorney very quickly because the timeline is 10 days and that's it. If you miss the 10 days, you punt on the driver's consequences and they just impose them. Okay.
I wanted so badly when the judge says you punt on the driving consequences. I wanted to make a football appear in the bottom corner of the screen and just go across at an arc. But unfortunately, I'm not that talented.
Okay, so your deadline for hiring a lawyer and figuring that out is really short.
Okay, so,
Yeah,
and
man.
like you said that, oh, sorry to interrupt, Your Honor. So you said that I need to come up with 5 lawyers that I can't afford to be able to get my state's attorney, my court-appointed lawyer stuff figured out? Is that what you said to try and do?
So what I'm telling you is this. I've denied your request for a public defender because you financially don't qualify for one. I will reconsider that application if you fill it out again and you provide proof that you just simply cannot afford an attorney. That attorney appointed through the Public Defense Commission can handle the criminal matter. They cannot and they will not provide you legal advice on the driver's consequence hearing. You need to find a private lawyer to do that for you if you want a lawyer at all. Nevertheless, two separate things happening at the same time with different dates, all arising out of the same conduct. Okay?
Okay.
All right. Do you understand now, ma'am?
Yes, Your Honor. Thank you very much.
Anything else, Mr. Gonzalez?
No, Your Honor.
Anything else, Miss Andrews?
No, Your Honor. Happy New Year.
Happy New Year to you too. With that, we are adjourned in this matter. Have a good day.
Thank you.
And I believe that
The jail. If I can have the jail come on, please. Come on, everyone. Let's shake off those 2023 cobwebs. It's a new year. It's January 2nd. Got a jail calendar. There we go. Willie McGraw.
Mr. McGraw is wanting to represent himself. He no longer wants the services of the public defender's office.
Okay.
We discussed taking a plea, but he rejected that offer and then decided he wanted to represent himself.
Okay. Let's see. Willie McGraw, right, wants to represent himself. All right, Mr. McGraw, raise your right hand. Do you swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
State your name.
McGraw, Willie James.
All right, and Mr. McGraw, you understand you have a constitutional right to an attorney, right?
Sure.
And you understand that because you're in custody, the public defender will represent you in these proceedings.
If I want them to, but I don't.
I understand. You have a right to waive that. I'm getting to that, but that wasn't my question. My question is, do you understand?
Yes.
If you're in custody, you have a right to be represented by the public defender.
Yes, that's part of the Fifth Amendment and the Seventh.
Okay, you understand that you have that right, right?
Yes.
Okay. And so you have decided that you want to waive that right. Is that correct?
Yes, sir, because as long as I've been in jail, I asked for like court files and stuff like that. I can't get nothing done. So this is the best option for me, period. I got the experience. So I know what I'm doing. I got it. Or should I say I have enough to know what I'm doing.
In my experience, that's not necessarily the case, sir, but
I
I'll
understand.
let you go forward.
Thank you.
I mean, because you do have a right to represent yourself. So you wish to exercise your right to represent yourself. Is that correct?
Yes, sir.
Okay, all right. And you don't want to be represented by the public defender. Is that correct?
No, sir. No, sir. Definitely not.
Okay.
Maybe at a different future date, but not right now. No, this been going on since September, and this should have been over with a long time ago. This is where the society have an economical collapse because of cases like this. This is a no-brainer. It should have been over with. No
Okay.
disrespect to you, Your Honor, but this is a no-brainer.
Well, I'm going to apply my brain to it. We'll see how this goes. So go ahead, sir. What are you seeking? I'll find that you waived your constitutional right to an attorney at this point and opted to represent yourself, and that the public defender is not representing you, and I'll release the public defender from the representation. So, Mr. McGraw, tell me what you want to tell me, or what are you asking for?
First, I need the court file, if it pleases the court. My second motion I will file is for video, audio for the officers, body equip he was wearing the day, so I'll be able to go through it to file the proper motions in the near future. Period.
Okay.
First, I need.
Well, I mean, so we'll hold on.
Well, since you added the punctuation to your verbal presentation, we'll make sure to get right on that, sir.
That's all you want, sir?
As of right now, yes, sir. There might be a motion for, I'm sorry. Speedy trial. I would like to ask for a speedy trial. I forgot I had to put that on record. But yes, I need a
Well,
speedy.
no, that if that's something you're asking for, you need to file that with the court.
Do I need to put that in writing for your court, Your Honor?
It is required to be in writing. You can't just,
Okay, I'll do that in the
you can't just do it orally in court.
Okay, well, in that case, Your Honor, I must let you know right now, as long as I've been in jail, I don't have a jail ID. It's required by the jail's commissary store clerks that if I want post stamps and paper and things like that, I have that jail ID. I don't have one. Okay, so I don't have access to paper, ink pens, and postage or envelopes. So to get this in writing to the courthouse, I'm going to need these items. And I wrote grievances in the kiosk machine like I was supposed to. And they said like last month in November, in November, they told me that they was going in the response of the grievance that they'd take care of it. And I still don't have an ID. And this is January 24th. So we're going to need that taken care of too. I don't know what you could do about it, but I'm gonna let you know. You just notify me. Speedy trial going to have to be in writing.
Well, that's true. So hold on one second. We've got well, that's weird. Yeah, all right. So at least, yeah. So well, for starters, I mean, this wasn't, it looks, William McGraw. All right, this is an accused case now, so that's good. I think what I'm going to do, let's start here. Just a note to the public defender, although I note that this was under Ms. Obiora and not so maybe two public defenders ago. Are you with us on a regular basis now, Ms. Dodge?
No, Your Honor, I'm just filling in for the day.
Got you. Okay. Well, anyway, I don't know who well, let me just say this. Bearing a speedy trial demand in a demand that has a bunch of other things in it is not a speedy trial demand. But I do note that there is a document titled that was filed in this case on October 16th, 2023 that says entry of appearance. Now, this was when this was an S number matter. Entry of appearance, motion for discovery, preliminary motion to suppress, motion for evidence favorable to defendant, and reserving further motions pending compliance with discovery. And there's a whole bunch of things in it. But the second item on the list is a speedy trial demand. That is not a proper speedy trial demand under any set of circumstances. We would have no way of knowing in that document that there is and that's why the statute requires.
I'm sorry, Your Honor, what is the statute? Because I'm not aware.
I'm about to read it.
Okay.
177170A. That is why the statute requires the demand for a speedy trial filed pursuant to this code section shall be filed as a separate, distinct, and individual document and shall not be a part of any other pleading or document. Point there is, if anyone thought that was a speedy trial demand in this case, I'd have no way of knowing. So, because we're just simply not looking at that document for anything from the court standpoint. So, but in any event, that was filed and, this has a C number. So where's the accusation? There's no accusation. Has there been an accusation in this case?
Yes, Your Honor, I downloaded it this morning thinking.
You did?
Yes.
23C05. I don't see it. Where is it?
It should be in documents.
Not a C number. I don't
It was
see an
filed on January 25th, 2021.
20. This is Mr. McGraw, right?
Yes, sir.
Oh, Your Honor, sorry, I opened the wrong accusation. McGraw?
In documents? All right, well, I don't know how this all happened, but let's make sure that this docket actually looks like a docket should look. There is an accusation. Okay. Well, there's a filed accusation, so let's go ahead and again flag this case and let's get with the clerk's office and make it look like a case is supposed to look. All right, we're going to flag this case. Mr. Pass going to get together with the clerk's office and make this docket look the way it's supposed to look like for an accused case. I had to do a lot of digging to find the accusation, and I shouldn't have to do that.
I think the judge's expressions and commentary are just as much fun as the pro se defendant. The judge cracks me up. He's so adorable, and his facial expressions are top notch. You never have to wonder what's going through his mind. Funnily enough, you don't have that problem with the defendant either.
All right, Mr. McGraw, I'm going to arraign you. And then, so I'm going to read the accusation to you. And then I need for you to let me know whether you plead not guilty, guilty, or no contest. Not guilty, guilty, or no contest. Okay?
Yes, Your Honor.
All right. Here's the accusation. In the state of Georgia, county of DeKalb, as to count one, on behalf of the citizens of the state of Georgia, the undersigned prosecutor is prosecuting attorney for the county and state aforesaid, does charge and accuse Willie McGraw with the offense of simple assault for that said accused on or about the 22nd day of September 2023, did place Officer K. Harge in reasonable apprehension of immediately receiving a violent injury by approaching in a threatening manner in violation of OCGA 16-5-20. As to count two, the undersigned prosecutor is prosecuting attorney for the county and state aforesaid, does further charge and accuse Willie McGraw with the offense of giving false information to a law enforcement officer for that said accused on or about the 22nd day of September 2023, did give a false name, to wit, James Spears, to a law enforcement officer in the lawful discharge of official duties with the intent to mislead the officer as to the accused's identity in violation of OCGA 16-10-25. As count 3, the undersigned prosecutor, as prosecuting attorney for the county and state aforesaid, does further charge and accuse Willie McGraw with the offense of obstruction of an officer for that said accused on or about the 22nd day of September 2023 did knowingly and willfully obstruct K. Harge, a law enforcement officer, in the discharge of official duties by failing to follow lawful commands in violation of OCGA 16-10-24A. The above offenses having occurred in DeKalb County, Georgia, contrary to the laws of the state, good order, peace, and dignity thereof, signed on behalf of the Solicitor General of DeKalb County, Donna Coleman Stribling. To these charges, how do you plead, sir?
Not guilty.
Okay. Well, let the record reflect that the defendant has entered a not guilty plea in this case. And so what I'm going to do now, since you've been arraigned, is set your case for calendar call at the end of the month. We're going to have the defendant produced here to the court room for a calendar call. So, and that way, so just so you know, Mr. McGraw, the jail is an entirely different branch of government than me. They are an executive agency.
Yes, sir.
Yeah, I don't control them. So I don't know how things work at the jail. We work together sometimes. They make sure that that courtroom is on my jail call. But I don't, it's a totally different branch of government. So what we're going to do is have you brought over here for calendar call. That's something the sheriff's office will work with me on. And then if you need anything, we'll supply it to you or whatever. I mean, we'll figure out what the path forward is for your case. We'll do that here in my courtroom at calendar call it's actually the beginning of February 1st, right? Yeah.
Okay, Your Honor, I need access to the law library. The jail don't have a law library.
I can't, like I said, I can't. I'm not going to be able to solve all of the issues here, sir, but.
Okay, can you give me personal bond then? I've been in jail since September. My bond was set at $50. It was at 150. It was lowered to like 100, then to from 100 to 50, I believe, somewhere like that. Because I know I had like 3 or 4 different bond hearings.
Okay, and so what was the what's the state's response there? Is Ms. Enoch Perry?
Your Honor, the state consents to a UJR. We would need a valid address.
Okay.
And probably an email address to fulfill discovery as well.
Okay, so you do all right. To the jail. Looks like you're getting out of jail today, Mr. McGraw. So to the jail though, I need Mr. McGraw to like give us his contact information so that Mr. Pass can update it in the court system.
I could provide the address where my mail goes to, and that's in my
No, I got that. But I'm asking, hopefully the deputy there in the courtroom. Is it Mitchell? No, not Mitchell.
Oh, Mitchell's not here today. I'll get the address from him, Judge, and put it in the chat.
Yeah, so I need a mailing address, a phone number, and an email address if he has one. Mailing address, phone number, email address. We'll put that in the chat. Mr. Pass will update that in the system. And then we don't even need to worry about February, this calendar call. We can go out a couple months.
Write it to where I can read it.
I'm sorry. It's been a minute. Sorry. I'm sorry.
I'm going to need you to notice this. We'll go to February 29th calendar call at 1:30 p.m. February 29th calendar call. Make sure a notice goes out.
Yeah, that's the street.
Phone number.
I don't have I'm sorry, I don't have a phone nor an email address. This the best I could do is just my address.
That's fine. February 29th calendar call at 1:30 p.m. in my courtroom, courtroom 3C of the DeKalb County Courthouse. So Thursday, February 29th at 1:30 p.m. in my courtroom. You need to be here, sir, okay?
Yes, sir. I know exactly where it's at. It's right around the corner from the MARTA station.
It sure is.
Well,
The
not
Decatur
exactly.
MARTA station.
It's right over. Yes, I know
You got
exactly
it.
where. So if I have any problems or any questions, I know exactly where to go directly to the clerk's office so they can verify anything I don't know or anything I don't get in the mail that's supposed to be there, like a
Well,
letter.
we're gonna mail you a notice.
That's exactly what I said, Your Honor.
But I've already told, you don't need to even worry about that notice. I'm telling you right now, you need to be here February 29th at 1:30 PM in courtroom 3C of the DeKalb County Courthouse. That
Like a letter, period.
very courthouse near the Decatur MARTA station.
I'm sorry, you did say 1:30 PM, right?
1:30 PM.
Thank you, Your Honor.
You got it. So it's going to be a UJR.
Yes,
Don't
sir.
violate the laws of any governmental unit or entity and report to court on a future date that I will set. You'll need to prepare that order, Mr. Powell. We have a form is out there somewhere. UJR. Don't violate the laws of any governmental unit or entity and report to court on a future date that that February 20, actually it should say February 29th at 1:30 PM in courtroom 3C. Okay. And that'll be your calendar call appearance, sir, because I just arraigned you. Okay.
Yes, sir. Thank you, Your Honor. One last thing I need to clarify with you, and that's restrictions. Are there any other restrictions on far as my release other than what you just told me? Far as like my traveling and things like that. I know I probably can't leave the state, but like leave the county. Can I leave the county going to like Atlanta or something like that? Because that's the address I'm providing.
You can go to Atlanta if you want.
Okay, thank you. That's all I would like to ask. Thank you.
Oh, right.
Your Honor, if I may bring something to your attention, the address provided by Mr. McGraw leads back to Bayshore Men's Homeless Shelter and Central Presbyterian Church. I need to know whether that is his permanent place of abode.
Where's Mr. McGraw? Well, let's have Mr. McGraw back up. I need to run and get a pen, so give me one moment, please.
I disagree. I think he'll be back because I think he's having way too much fun showing how smart he is representing himself.
It's fine, but I take out, it looks good. Take out take out as directed, sorry. You don't need that there, so just, yeah, on February 20. Yeah, so just take out as directed. That'll be fine. Okay, yeah, so sir, do you live at that address?
No, not direct. It's a community mailing address by mail. I have more than enough income to live in my hotel room.
Okay, well, I mean, I guess no matter, but that's where the address where you get mail, right?
Yes.
And so you're gonna receive that mail that like if we mail you a notice, you're gonna get it, right?
Of course. I'm sorry, guys.
Well,
see, like,
I mean, because here's the bottom line. I mean, from my standpoint, at this point, it doesn't matter. I've told you when you need to be back in my courtroom, like when and where you need to be.
Yes.
And also the bond order that you're going to get from me at the jail it has on it when and where you need to be. So you don't show up that day, I'm going to issue a bench warrant. But you know, and if you do, then you'll get another notice for your next court date from us. So I mean, I guess at this point, it really doesn't matter. But we will mail stuff to that address if that's where you receive mail.
If I have any issues, I understand I have to contact the court immediately.
Well, no, yeah, that's right. If you have any issues at this point, that's on you, sir.
Right.
Okay, all right. Because we've done everything we can to make sure that you get our mail. And on top of that, I've given you good notice.
Yes.
Okay, sounds good. Thank you.
Yes, thank you, Your Honor.
All right. Andrew Crockett, according to Mr. Pass, he's not on my calendar, but Mr. Pass says we have an Andrew Crockett that should be on the calendar. Yes? No? Maybe?
Yes, Your Honor. I believe we'll be able to resolve that case today. I think he's going to enter into a revocation.
Okay. All right. So it looks like Corey Prophet needs to talk to the public defender and Andrew Crockett. Is that correct?
Yes, Judge.
All right. If I can get the jail to make that happen, and then come on back and let Mr. Pass know when that's been done, and I'll come and address these last two cases.
Will do. Thank you. Your Honor, I'm ready to proceed whenever everybody's back.
All right. Where do things stand?
I'm ready to proceed on the probation revocation hearing for Mr. Crockett.
Okay. All right. So Andrew Crockett. So is this a consent?
No, Your Honor.
Okay. Well then, Officer Cameron, raise your right hand. Do you swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
State your name.
Officer Brittany Cameron.
All right. Tell me about the case.
The defendant would enter a guilty plea of the offense hit and run 3 counts and driving while license suspended at the January term of 2016. He was to serve 24 months consisting of 7 days in confinement, credit for 7 days, and remainder on probation. Payment of the defendant in the final amount of $706.50 and the restitution of $2,321.61 was the condition of probation. Defendant was to pay $39 supervision fee. Defendant was to perform 40 hours of community service. Defendant is to complete a defensive driving course. The defendant may work off fines and fees at $8 per hour. Non-reporting probation once all conditions are met. He failed to report as directed on April 27 of 2017. He failed to pay the fine, restitution, and supervision fees, paying $110 to date, having a balance of $3,581. He failed to complete the community service, working 0 hours to date and owing 40 hours of community service. The sentence was told in May 24th of 2017. It has been 6 years, 6 months, and 21 days since it has lapsed. There are 6 months and 12 days remaining on the sentence.
So he hasn't paid restitution?
Yes, sir.
Okay. What's the response, Ms. Dodge?
Yes, Your Honor. As Officer Cameron just stated, Mr. Crockett still does owe that restitution, and he is aware that he needs to pay it at this point. My ask would be that he be reinstated on probation to pay that balance. This is a case from 2015. He's had no criminal history since 2016 when he entered this plea. He is currently working. He works for a moving company, and he earns enough money to pay off that restitution. He unfortunately was unclear about what exactly he needed to pay and didn't realize he still needed to make those payments. And when he also told me that he never received a notice of his violation of probation hearing back in April of 2017. So I believe that's when his probation was told. Again, Your Honor, I would be asking that he be given the opportunity to pay that restitution, have his probation reinstated, and then his case closed once the restitution is paid off. and also that he received credit for time served. He's been in custody for 20 days since he was arrested back on December 14th.
Well, there wouldn't have been a probation revocation hearing. I mean, so what? I signed a warrant and a tolling order, right? On an
I'm sorry,
application.
a violation of probation.
Well, I don't find any of that credible. So we're just going to start there. It's a hit and run case and a driving with suspended license case that has some kind of damage to a third party involved because restitution was awarded. The defendant was here for his sentencing. I guess he entered a plea. I mean, this case didn't go to trial, right? This was a plea.
Correct, sir.
Okay, so he was here for his plea, which means on top of me sentencing the case and telling him what his sentence is, he worked out the deal. Let me just make sure it was a plea and not a trial. But I don't want to speak without.
Based on my notes, Your Honor, it was a plea.
Yeah, so it was a plea. So that means he worked it out with the state with in full knowledge of what the deal was going to be. Voluntarily took that plea in front of me in the courtroom. Back in 2016. And so knew what the deal was at the time. And I mean, so the notion that I didn't know is I'm not buying that at all, sir. Just, you understand?
Yes, sir.
Yeah. Okay. And then, you know, he didn't know about the restitution. Well, we can start here. He didn't even pay the fine. So, I mean, you know, he paid $110 toward the restitution and fine. But bottom line here is I'm going to revoke and close. I'm not going to, I mean, I've been waiting since when did I sign this tolling order? 2017.
Yes, sir.
Yeah. So I've been waiting since 2017 to see this defendant back in front of me on a hit and run case. So I'm not feeling it's unfortunate that the consequences of this case is that damage was done to some third party out there. And the defendant never made amends to that. So he damaged some third party, entered a plea to that, and never made that defendant whole in a hit and run case. And then I couldn't find him, you know, for the better part of 6 years. So there's going to be a revocation and close in this case. And we're going to just wrap it up that way. I just need to figure out how long the revocation is going to be. So and I'll give credit for the 20 days time served. But I don't have a lot of I don't have patience for a hit and run case where the court has been made to wait this long to get the defendant back in front of me. A hit and run case where someone was damaged, and then here we are, you know, years later to wrap this case up. All right, here's what I'm going to do.
Get up, go. Yeah.
And so Ms. Dodge, at some level, you might need to be involved in this, but I'm my decision. So let me just recap where we are. I've been presented with a defendant who was sentenced back in 2016 in a hit and run case that included a significant amount of restitution and basically just lied to me about not knowing that that was required of him. And this case has been going on for years. I'm going to revoke 90 days credit for the 20 days time served. You're lucky, sir, that I didn't decide to revoke the balance, because that's what I was trying to decide.
Thank you, Your Honor.
And well, so what I will do, the public defender is welcome to if he can. So right now, just the sentence from the clerk's office needs to be revoke 90 days, credit for 20 days, and close. If the defendant is able to find a way to pay the restitution of $2,321.68, $2,321.68, the amount that is supposed to be paid to the third party who is damaged in this case, the public defender is welcome to bring the case back in front of me, in which event I will revoke time served and close and waive everything else but the restitution, which will need to be paid to the third party. But right now, the decision, what the clerk's office needs to send me is revoke 90 and revoke 90, credit for 20, and close. And if the public defender asks us to put this back on the calendar, we'll put it back on the calendar. And the only reason it should be back on the calendar is that the defendant can pay the restitution. And if he can pay the restitution, then I will amend this decision to be revoke whatever amount of time was served, credit for whatever amount of time was served, pay the restitution, suspend all the other requirements of the sentence, and close.
Yes, Your Honor, understood.
All right. Sounds good. That's my decision.
I think the judge played it right there. You give him too much time, and he becomes complacent, doesn't care. He wants to give him enough time that there's incentive for him to, be calling all of his family and friends and being like, if you do this, if you get me this money, then, hey, I can come home in 2.5 months, make this happen for me. He's going to be more excited about getting out and getting the injured party paid off than if he was to be given a long drawn out sentence revoking everything. I think he deserved to have everything revoked, but I think the judge wanted to make it just long enough for him to be able to taste home now.
We're here for a probation violation hearing. He's represented by Mr. Greer. There's been a recommendation made by the probation department that on guidelines of 0 to 6 months, they're recommending that his probation be continued. He served up to 270 days in jail with credit for 132 days. And Mr. Stade, you adopt that recommendation as an offer in this case?
People do.
All right. Mr. Greer, is that your understanding of what the offer is?
It is.
Does your client wish to take advantage of that offer, or does he want to?
He wishes to plead guilty, Your Honor, and ask the court not to exceed guidelines of 6 months.
All right. Is that correct, Mr. Kaling?
Yes.
Would you raise your right hand, please? You solemnly swear, oath, and affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. The allegations here are that you were placed on probation in this court for the 5-year felony offense of operating while intoxicated, third offense. Do you understand that?
Yes.
You're alleged to have violated your probation in count 1, that you violated condition number 2, when on or about October 20th, 2022, you left the state of Michigan without permission. Do you understand that?
Yes.
And that condition number 3, was that on or about October 12, 2022, you failed to report as instructed and did not report as instructed for at least 60 days thereafter. You understand that? Yeah. Now, the agreement in this case is that if you plead guilty to those violations, and dismiss the other violations, you're to remain on probation, and you can get up to 9 months in jail with credit for the 132. Your attorney can ask for less, you can argue for less, but that's not the agreement. The agreement is that you could get up to 270 days. Do you understand that?
Yes.
Is that your complete understanding of the agreement in this case?
Yes.
You had sufficient time to consult with Mr. Greer about these allegations, the right to contest them at a hearing, and this plea agreement.
Yes.
Subject to the plea agreement, how do you wish to plead?
Guilty.
You understand that if I accept your guilty plea, that you're giving up the right to contest these allegations at a hearing?
Yes.
You also understand that you'd be giving up all the rights that you would have at that hearing?
Yep.
We listed those rights for you on a written advice and right sheet that you signed back on December 22nd. Did you read that document?
Yes.
Did you understand those rights?
Yes.
You also understand that that you may be giving up the right to appeal any appealable issues you would have if you went to a contested hearing and I found you guilty.
Yes.
You understand that you're giving up your right to appeal this conviction and sentence. And if you wish to file an appeal, it would be by application for you to appeal in the Court of Appeals.
Yes.
Has anyone threatened you to get you to make this plea?
No.
Has anyone promised you an outcome different than what we put on the record? You're renting this plea of your own free will.
Yeah.
Understand that if I accept your guilty plea, you're giving up the right to later claim that this plea was not your choice, or that it was the result of any promises, threats, or inducements which are not disclosed to me today.
Yes.
Do now give up your right to contest these allegations at a hearing, and all the rights that you would have as associated with that hearing, and do you affirm your guilty plea?
Yes.
Is it true then that you were placed on probation to this court for the 5-year felony offense of operating while intoxicated, a third offense on July 13th, 2021?
Yes.
It's also true that it was a condition of your probation is that you not leave the state without getting permission.
Yes.
Did you violate that condition?
Yes, sir.
Did you leave the state on or about October 20th, 2022?
Yes.
Where'd you go?
Went back to provide for my family. I went to oil rigs to Texas. I'd work a month at a time and come back and forth.
So you went to Texas and you did not get permission, correct?
Yes.
All right. Is it also true that a condition of your probation was that you were to report for probation?
Yes.
And were you scheduled to report on October 12th, 2022?
Yes.
Did you fail to report as instructed?
Yes.
Did you fail to report for at least 60 days thereafter?
Yes.
All right. Are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor. No, Your Honor.
Is the defendant competent to enter this plea?
Yes. Yes, Your Honor.
Has the court complied with the court for taking a plea in a probation violation case?
Yes, it has.
All right, the court does accept the plea. You find it be knowing, understanding, voluntary, and accurate. There's been an updated report prepared. Do the parties wish to proceed to sentencing today?
The people do. Yes, Your Honor.
Is the report available to you?
It was. Yes, it was.
And Mr. Beard, have you had the opportunity to read the report and discuss it with Mr. Kalin?
I have.
Do you have any additions, corrections, or challenges?
Your Honor, I found it to be accurate.
Your Honor, if I may real quick.
Yes, sir.
Just one thing to point out, the jail credit is actually inaccurate on here. It was my understanding, Mr. Kaling, bonded out of jail on 12/27, which would make his jail credit approximately 126 days, not 132.
Okay. All right. I'm sorry for the interruption. Mr. Greer, is there anything that you'd like to say on his behalf?
Well, Your Honor, he readily admits that he left the state. He was working in Texas. It's a job that can bring him some pretty good money quickly. He came back here. He was working now as a logger for a guy named David Dennis. he told me that he hasn't been drinking for a substantial period of time. You know, I look at his record and it's all alcohol related. A 2013 drunk driving or impaired driving, 2015 out of Mecosta County was a drunk or an impaired and property damage accident, and then this one. So he's got those misdemeanors and then the one felony, which is this. I would ask the court to take that into consideration. And, you know, he knows now he's got to get busy on this community service and he's got to start paying attention to the probation. You know, and doing an additional 90 days or whatever is certainly punishment enough, I think. I would ask the court to not exceed the guidelines and give him a 6-month sentence with credit for the time that he served.
All right. And Mr. Kaling, have you had the opportunity to read the report and discuss it with your attorney?
Yes.
Do you have any additions, corrections, or challenges?
No.
Anything that you want to say on your own behalf?
I was wondering if I signed up for rehab. I do want to go rehab. If there's any way I can do that.
Why do you need rehab? Your attorney just said you've been quit drinking for a long time.
Because just to make sure, I guess.
You back to drinking?
No.
Sounds like you'd rather go to rehab than jail.
Yes.
Well, that's a dumb thing to admit. Nothing says, Your Honor, I don't take this seriously. Like, can I go to rehab just so I don't have to go to jail?
Now, you were working up at Advanced Energy in Traverse City. What were they paying you?
It was $5,000 a week.
$5,000 a week they were paying? And what were you making out in the oil fields?
Wasn't advanced. Advanced Energy is out of Traverse City. That is where I was working out of, not in Traverse City.
Oh,
in
Texas. Texas, yeah.
Oh, so the whole time you were plugging in was $5,000 a week.
Yeah, that was only 2 months.
Yeah, but in 2 months, you have literally made more than I make in an entire year. With both my Social Security disability and my YouTube career combined. That's a lot of money.
Then what happened?
That went back to logging.
Why?
Too much getting there back and forth. It's too much.
What are you making logging?
Like $700 a week cash.
Why didn't you just ask for permission to go?
I don't know. I should have. I know I should have. I thought I was going to be getting in a lot of trouble, so I thought.
Well, you would ask before you go.
Yeah.
Not just do it, you know?
I know.
Could have put you on an alcohol tether or something like that. We probably could have made it work.
Really?
Anything else that you want to say, sir?
No.
Mr. Stay, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
No, Your Honor.
That's
All right, the court recognizes that the advisory guidelines would suggest a sentence between 0 and 6 months. The courts can exercise by discretion and exceed the advisory guidelines. It'd be the sentence of the court for this defendant serve 210 days in the Nuevo County Jail, given credit for 126 days, and exceeding the advisory guidelines because of the time that he has been absent from the state, and essentially he hasn't done anything that he was supposed to do in terms of probation. I'm going to continue him on probation under the same terms and conditions. You still owe $881.60. How soon can you pay that, sir?
Immediately.
Pay that today? So
I could if I could get out. Yeah, I could definitely pay it
you're
today.
not getting out.
Oh,
So what's immediately to you?
What was that? I don't have the best hearing.
$881.
I'd have to call and talk to somebody.
Can you do it within 30 days of your release?
Yes.
All right, I'll give you 30 days after you're out of jail to pay the financial assessments.
All right.
I'll give you one more shot here. So, we're drinking,
No drinking.
gotta get your therapy, gotta do your community service work,
Yeah.
gotta do it all, by the book,
All right.
all right?
Yep.
You're doing the right to make application for leave to appeal your conviction sentence. If you cannot afford an attorney, the court appointed attorney to represent you on the appeal. The request for a lawyer must be filed in court within 42 days.
Your Honor, if I may,
Yes.
can we make it a, order of the court to that his probation be extended for an additional year to allow him time to complete that successfully?
All right, we'll do that.
Thank you.
All right, man.
Oh my. So the judge exceeded the recommendation. Yeah, and I loved the judge's when he said, well, yeah, if I could get out, and he's like, you're not getting out today. No, not gonna happen, buddy. Okay, guys, so this is the clip that CapCut refuses to allow me to export my entire docket today because of. So, I hope y'all enjoy this. There are some parts where the audio is absolute garbage, but the magistrate has them walking around and giving a microphone to people when that happens. So, yes, I left in the crappy audio parts, but you'll still get the idea. And I have to go get Billy. He's outside and he's begging to come in.
All right. Good morning, ladies and gentlemen. I'm Judge Vigorito. I'm the magistrate judge this morning. Stephen Avila. Avila. Mr. Avila, you're charged with a Class A misdemeanor assault causing bodily injury to a family or a household member. Your bond amount set at $2,000. You're not going to get a personal bond. You need to go through a bail bondsman or a lawyer to get out. Now, bail bondsman, if they want to do it for 10%, would be around $200.
Why am I not getting a personal bond?
Because you have a criminal record that's very, very long. That's number one. And number two, there is some concern about the safety of the alleged victim in this case. And under those circumstances, I'm not comfortable doing a personal bond. I don't mind you asking, but that's the reason. I mean, I can't count all your arrests. This is over 100 of them, I think, since 2001 all the way until this year. And now we're talking about this. I set your bond low, all things considered, because I don't want it to be too financially difficult for you to bond out of jail, but you are going to need to go through a bail bondsman.
I want to go to a bail bond person. If I have no contact information from nobody, I can't call nobody. I have nobody to call.
Well, I hear you, and I don't have a great solution to that. Okay.
They didn't give me access to no cell phone, sir. No cell phone. I couldn't get no phone number for my cell phone.
Hey, Cyprio, can you get the mic? So I can.
They didn't give me no access to my cell phones or nothing. I have no numbers. I can't talk to nobody at all out here. If I can get personal bond, sir, I promise I'm gonna go to my court dates.
Under the circumstances, and I don't mind you asking, but under the circumstances with the information that I have about this case,
The case. She admitted to the case that she hurt herself, and then I pushed down on her bruise or something like that.
well, I don't want you to make any statements about the facts of the case. I'm familiar with the allegations. I can tell you that the statements she made to the officer are a bit different from what you're sharing. But you need to talk to your lawyer about your side of the
I
story.
don't have a lawyer.
Well,
I don't have no money, sir. I have no money. I have a job in California, which I had my bags packed. I have my bags packed, sir. I have my bags packed. I was on my way to the airport when I was on the way out.
Oh, yes. Nothing says I'm not a flight risk like I have my bags packed. Oh, it's a interesting strategy.
I don't belong in Texas. If you're to bond me, if I was to bond out, I'm going back to California. I have a job. I have things to take care of over here. I was only over here for a couple of days. I don't live over here in Texas.
I understand that. I see that. But under the circumstances, based on the information that I have, I do have some concerns about the
How am I
safety.
supposed to bond out though? How am I supposed to bond out? Like, I can't call nobody.
Well, the bail bondsman, if they want to do it for 10%, would be around $200. Do you have?
How? I don't got that money. I'm gonna cash on me. I don't got nothing on me, sir. I can't bond out. So I'm gonna be
You have
stuck
to
in
talk
jail.
to your friends or family about it.
I can't talk to nobody. I don't know
get it.
nobody's number.
Well, normally when they arrest you and they book you in, normally
They
what they
didn't let me get they didn't let me get no phone number for my phone. So I have no number. So I'm stuck in here until I go to the court. I'm gonna lose my fucking job for, I'm sorry, excuse my language. I'm gonna lose my job. I'm gonna lose I'm gonna lose my house over there. I'm gonna lose all this shit for what? For some bullshit ass charge over there that I didn't do?
Well,
can I please get personal bond, sir?
I'm telling you, I'm not comfortable doing it, and I'm not going to go through all.
Oh, you're not comfortable doing it. I'm not a threat to nobody.
Look, I'm not going to argue with you. What I'm telling you is you've been arrested like 100, 150 times nonstop since 2001. It's like you get arrested 5 times a year for the last 23 years. And I do have concerns about the safety of the victim in this case. I'm not going to go
The
through
victim
that.
is the only person, the victim will be the person to probably pay my bond.
I'm not going to argue that.
My bond.
Your bond amounts $2,000. Do you want a court-appointed attorney or do you want to hire your
I
own
want
lawyer?
a court-appointed attorney, man. Bye.
Now, you also have an emergency protective order that's being issued in your case, Mr. Avila. This is for the protection of Sue, and it prohibits you from doing 5 things. First of all, you're prohibited from committing family violence against her, which is already illegal. Second of all, you're prohibited from communicating with her or members of her household or family in a threatening or harassing manner. Third, you are prohibited from going within 200 yards of. You cannot go within 200 yards of that address. Now, I know you may have some personal belongings there. You need to have someone else go there, get your stuff for you, and bring it to you. You cannot go within 200 yards of that address. And lastly, you're prohibited from carrying a firearm or ammunition. This protective order is going to last for 2 months, almost until February 28th. You're going to get a copy of it. You need to read it and comply with it, because if you violate it, it is punishable by up to a year in jail.
Hey, Judge. Only person's number I have is Sue Helen's number.
I do understand.
I'm gonna call Sue Helen for her to bond me out.
So
that's the only person I can call. I have no one else's number.
I understand. Now, what you could do, first of all, I could tell you that normally when you get booked into the jail, they give you an opportunity to write down any numbers you need from the phone. I don't know why that didn't happen in your case, but I could tell you that normally they offer that, though I can tell you that won't happen if you're being too disruptive. I don't know whether that was a situation when you're with you at all. What I also can tell you.
The deputy was just being an asshole.
Okay, well, I can tell you that you've been talking to, if you were talking to him the way you're talking to me, then that might be an explanation. Okay? Just being honest with you. Now, what I can tell you is that when you get back to your jail cell, you can ask the post officer if there's any way that an exception can be made for somehow you to be able to get access, to be able to write down some phone numbers from your phone. I could tell you that it's not a normal that's not a normal procedure, but that's not something that's up to me. I can also tell you, stop interrupting me. I could also tell you that when your court-appointed attorney reaches out to you, they can do a property release for your phone to get phone numbers and things of that nature. What's that?
I ain't hear no more, bro. I hear a bunch of bullshit, bro.
All right. Good luck, Mr. Avila. Andrea Foster.
Who?
Andrell Abrion Foster.
Bullshit, bro.
Mr. Foster, Mrs. Foster, you are charged with a Class A misdemeanor, assault causing bodily injury to another. Your bond amount set at $3,000. However, you are going to get a personal bond. You are going to be released today for free based on your promise to come to all your court dates.
That's crazy. I don't know why I didn't get personal bond, man. That's crazy.
You do have 2 conditions you need to comply with, Ms.
I'm sorry, bro. I'm sorry about that, bro.
Mr. Avila, the way in which you're conducting yourself right now only confirms to me that I've made the very correct decision in my assessment of and my concerns that I've expressed. Just letting you know that.
Hey, get out of here, bro. Hold on. Shit.
Miss Foster, can you raise your hand, Miss Foster, so I know who I'm talking to? Okay, Miss Foster, you're going to be released on a personal bond, but you have a couple of conditions you need to comply with. Number one, you're not allowed to have any contact with the alleged victim in this case, not by phone, email, text message, nothing. Number two, Miss Foster, you are not allowed to go within 200 yards of Parkway, that whole apartment complex. You cannot go within 200 yards of that under any circumstances. Do you understand that?
Yes.
Do you want a court-appointed attorney or do you want to hire your own lawyer?
If I choose one, if I needed to change it, can I? That makes sense.
You can request a court-appointed lawyer now, and then if later you decide to hire your own, they can substitute in for the court-appointed lawyer. Does that answer your question?
Yes. So I'll do it as part of the.
You'll do a court-appointed lawyer now?
Yeah.
Okay. All right. Any other questions?
Would you happen to know if my car is still at the apartment? Or if I need to get a tow?
Say it again.
Would you happen to know if my car is still at the apartment? If I can't go there?
I don't know. I can tell you, you can have a friend or a family member go over there and get it if it's there, but you cannot go back there under any circumstances, okay?
Okay.
How the hell would the judge know if your car was still at the apartment complex? What?
Would they normally tow, to your knowledge?
I have no idea whether that apartment complex would tow and under what circumstances. Good question, but I don't know the answer to that question.
Okay, thank you.
All right. You will be released today, so yeah, it shouldn't be that long that the car is there, and hopefully it's not been towed, but you need to have someone else go and get it for you. What's that?
Thank you.
All right, Shira Martinez. Miss Martinez, you are charged with a Class B misdemeanor driving while intoxicated. Your bond amount set at $2,000. Miss Martinez, how long have you lived here in Austin?
About 2 years.
Can you put the mic, use the mic?
I've lived here since 2020.
And do you have family here?
Yes.
Which family?
My mother.
Your mother? Okay.
Yeah.
And is that who you were living with?
I was living with her for a couple years and I moved.
Who do you live with now?
Me and my son.
Okay, y'all don't live with other people though.
No.
And it's my understanding from our staff talked to some of your family, and they indicated that you were possibly moving to New Mexico. Is that correct?
Probably within the next few months.
Well, you understand you need to show up for all your court dates here in Travis County?
Yes.
Are you
Yes,
gonna
sir.
have the capacity to come back?
Yes, sir. I'll probably stay until all that's over though.
Are you working at all?
Not right now.
Do you live in an apartment complex?
Yes, sir.
That dude just won't stop. Are you working right now? No, I got a job. Too bad. Not anymore. By the time you get out, you won't.
Go by the NPR. Go by the NPR. Shit. Hey, NPR you watch. And you got murder on your shit. NPR, you just NPR me. I ain't no criminal.
He just said I ain't no criminal. Sir, you have over 100 cases against you. Possibly over 150. The judge didn't take the time to count them all. And who could blame him? By the very definition, you're a criminal.
I was straining out American.
Ms. Martinez, your bond amount set at $2,000. A final decision on the personal bond has not been made yet. I'm gonna make that in the next couple of hours. If you do qualify, you'll be released today for free based on your promise to come to court. If you don't, then you'll still be here by dinner time, in which case you're gonna need to go through a bail bondsman or a lawyer. As I mentioned, bail bondsman often charge around 10%, which in this case would be $200, which is not too much. Hopefully your friends or family can come up with that if I don't do a personal bond. Now, if you do postpone and get out of jail, whether it's through a personal bond or bail bondsman or otherwise, you need to be screened for alcohol counseling. You'll have a piece of paper telling you where to do that screening. You need to go to whatever classes or group meetings they require. Do you understand that?
Yes, sir.
All right. Do you know where your child is now?
Yeah, it's with my mom.
Okay, good. So they're being taken care of. All right. Just making sure. All right. Do you want a court-appointed attorney or do you want to hire your own lawyer?
Court appointed.
Do you have any questions?
No, sir, thank you.
All right, good luck.
Everyone.
Donna Hanson. Ms. Hanson, you're charged with a second-degree felony burglary of a habitation. Your bond amount's $4,000. You're not going to get a personal bond. You need to go through a bail bondsman or a lawyer. Given that you're unhoused and given your financial situation, I've set your bond low for a burglary case, but you're going to need to come up with $4,000 or go through a bail bondsman or a lawyer. If you do postpone and get out of jail, Ms. Hanson, you are not allowed to go on the property of Coronado Hills. You can't go back on that property under any circumstances, anywhere on that apartment complex, and you are required to report to a mental health supervision officer while your case is pending. So if you do postpone and get out of jail, you'll have a piece of paper with the name and number of a person that you need to contact within 24 hours of your release from jail, and you need to report in to them and whenever they require, and they will make sure that you get any help you need if you do need any help from in terms of mental health assistance. Do you want a court-appointed attorney or do you want to hire your own lawyer, Ms. Hanson? Court-appointed. All right. Do you have any questions? No? All right. Good luck. Cortez Joseph Keith.
And let the fun begin.
Is your first name Keith?
It is.
It is. Your first name's
Cortez.
okay. Your last name's Keith. Okay. All right. Mr. Keith, you have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 charges from 3 different episodes. With regard to the most recent charges, based on an incident that occurred yesterday, you have a second-degree felony robbery by assault with a bond amount of $15,000. You have a third-degree felony unlawful possession of a firearm by a felon with a bond amount of $15,000. You have a second-degree felony possession of controlled substance with a bond amount of $10,000. You have another second-degree felony possession of controlled substance with a bond amount of $10,000. And you have a Class A misdemeanor possession of controlled substance with a bond amount of $3,000. On this incident yesterday, you have those 5 charges. Let me finish. And you have a couple of conditions you need to comply with. And that is, you're not allowed to have any contact with the alleged victim in this case. And you are required to stay 200 yards away from McKinney Falls Parkway, which I understand is where you live. You're going to have to find another place to live. You cannot live in that apartment complex, and you cannot go within 200 yards of that apartment complex. And I know you have personal belongings there. You're going to need to have someone else go there, get your stuff for you, and bring it to you. You cannot go within 200 yards of that apartment complex. Do you understand that? Now, that's the 5 charges from yesterday. You also have 3 charges arising out of some incidents that happened earlier in 2023. You have a first-degree felony aggravated robbery with a bond amount of $50,000. You have a second-degree felony aggravated assault with a deadly weapon with a bond amount of $50,000. And you have a first-degree felony engaging in organized criminal activity with a bond amount of $50,000.
Shit, bro, y'all trying to make sure I'm bond out. I ain't
Total amount of your bonds on those robbery cases, which is all rising out of the same incident, is $150,000. One of the conditions on your case there, if you postpone and get out of jail, you're required to be on an electronic monitor. You're not allowed to leave. You're under house arrest when you'll have to have. monitor
Like cage, how y'all let somebody in a cage lie on my name because he facing all them charges and put them on me? How the fuck can y'all do that? Cause somebody lying on me and I'm already in jail? What the fuck? That don't make sense. Y'all just trying to make sure I don't get out.
You can talk to your lawyer about it. You certainly have the right to fight it, and you can ask for a bond reduction hearing.
Talking about, bro. Hit that shit, bro. Fucked up, man.
You need to be on electronic monitor. You're not allowed to leave the house except by permission of the monitoring agency. And you're not allowed to possess any firearms while this case is going on. And you're required to report to a supervision officer while your case is pending. That's on these 3 cases. And then you have 2 more cases that are a solely separate incident. There's a 2nd-degree felony burglary of a habitation with a bond amount of $15,000 and a Class A misdemeanor assault causing bodily injury to a family member with a bond amount of $7,500. And on that one, you have an emergency protective order that's being issued in your case, Mr. Keith. This is for the protection of Danielle, and it prohibits you from doing 5 things. First of all, you're prohibited from committing family violence against her, which is already illegal. Second of all, you're prohibited from communicating with her or members of her household or family in a threatening or harassing manner. Thirdly, in this case, you're not allowed to have any contact with her or members of her household or family at all, not even by phone, text message, or email, which means you're not allowed to call her from the jail. You cannot have any contact with her while this protective order is in effect. Fourth, you're prohibited from going within 200 yards of US Highway 290. You cannot go within 200 yards of that address. That's apparently some type of apartment complex or extended stay type thing. You can't go within 200 yards of that address.
Yeah, worry about that.
Lastly, you're prohibited from carrying a firearm or ammunition.
Cage who locked up for some shit, lied, put it on my name.
This protective order lasts for 2 months till March.
How y'all let a nigga who locked up for some put it on my name because he locked up? Apparently he's scared and don't want to go to jail. He put it on somebody else. I'm not worrying about that other shit. Them other 3 high-ass cases. How the fuck y'all let somebody who in jail already, who got a bunch of cases, say my name and put it on me? That's what I'm talking about. The fuck, man?
Well, Mr. Keith, I'm familiar with all of the police reports on all 10 cases, and I can tell you that I'm in full agreement that there's probable cause to charge you on every single one of those. Now, you can fight that, but you can ask for an examining trial. Your attorney can ask for an examining trial to argue that there's no probable cause to charge you. You certainly have the right to fight your case, and I want you to have your day in court. But I do think that these charges, that there is sufficient evidence to charge you. Now, you're going to get a copy of this protective order. You need to make sure you read it and comply with it, because if you violate it, it is punishable by up to a year in jail. Do not have any contact with Danielle, not even by phone. Do you understand that? I'm just stressing that. I don't want you to come back to jail unnecessarily if you bond out. You understand that?
It wouldn't be unnecessarily. Dude shouldn't get out.
All right, so the total amount of your bonds on 10 cases is
Yo, how the fuck he get to save himself? Like, man, I want there for none of this shit. That's power shit.
$225,500 is the total amount of your bonds on 10 cases, almost all felonies. I think it was 8 felonies and 2 misdemeanors. Do you want a court-appointed attorney, or do you want to hire your own lawyer?
You said how much it costs for all of it. If I get a bail bond for 10%, how much is it cut down? I'm talking about how much that high-end bond is.
That'd be around $22,000.
All right, nigga, stop your ass.
You want a court-appointed
I
attorney?
want court-appointed.
Court-appointed.
Power, bro. Y'all let niggas can't lie on me. That's why the shit's so high. This bullshit ass shit. This nigga.
Do you have any questions, Mr. Keith?
Fuck you. That's the question, bro. Real talk. I got a question. That's bullshit, nigga. A nigga get the spit way I put me in danger, man. I got a question. I'll ask him. Oh, I see it, man.
You said it's illegal to call Sue Helen and harassing frame, but is it? I could call her, right? I used to call her, ask her to bond me out, right?
So in your particular instance, I have not prohibited you from having contact with her.
All right.
Now, hear me out for a second. I wanted to make sure you're clear on the conditions. You do have a protective order that is in effect, and it does prohibit you from going within 200 yards of her address, and you are prohibited from communicating with her in a threatening or harassing manner. You're not, but you're not prohibited from calling her. I would just stress to you, make sure that you don't communicate in a threatening or harassing way, okay? All right, I just want to make sure you're clear on that. You're allowed to call her. Just make sure you don't communicate in a threatening or harassing way.
Sorry, man.
Oh God, I got some crazy ass things about some of the shit that other nigga did. Man, let's get it, man.
Hold on a second. Can you say it again?
No, we already talked to you. It's the same shit, man. Come on. Chill out, man. Chill out. No, I'm saying it's the same shit.
I think PR, sir.
Nigga put on me. Real talk that I ain't even do. I only hear the lame shit, man. Talk, bro. That shit $200, nigga. You can get it. I can get it. Yeah, that shit $200, man.
Oh my gosh. Now he's turning on the other guy. The last guy's turning on the first guy. That's $200. You can get it. It ain't like you got my problems, bro. Well, hey, at least he's encouraging guy one. You can get it. Oh, he's mad. He big mad.
Dang, I'm facing some shit because a nigga lied on me because he don't want to face prison. Come on, that shit $200.
Make sure you show up for all your court dates, obey your bond conditions, stay out of trouble. Good luck.
I'm so fucking shaking, man. Y'all don't like me so much.
Please reading PR in me, sir. Please, I have no people talking right now.
Shit, we in jail. Handle something, man. This shit fucked up, bro. On my mama, y'all know this nigga trying to, cause he don't want to.
I'm not from out here, sir.
Guy one, he kept trying to the very end. Oh, as they're leading everybody out, he cups the microphone. I'm not from around here, sir. Sir does not care. Oh, he handled it. He handled it quite well. He all things considered, but I have a feeling that magistrate has had that happen at least a dozen times or so. Oh, arraignments are the best. Yeah. Manny was counting how many times I violated community policy. Oh, yep. Yeah. That's why I said I had to leave the other hearing in for context, because he referenced it. And I love how he was like, no offense to you guys. No offense to you guys, but I'm going to bring you up to try to make myself look better in comparison to what y'all done. Oh, yeah. So now you guys, I hope you understand why I spent 2 days almost exclusively editing that show on 2 different softwares. Yeah. Thank you. I happened to enjoy it. including the super masturbation that we had earlier, I guess. Thanks, Morty. Thank your blubbering ears. I was not going to let that docket go. You guys had to see it. I had to see it. That was wild. Hi, baby boy. My my doorbell cam was going off, right? Let's see. Oh, maybe hold on. Don't you dare escape me out. Me out. Get it? Okay, so my doorbell cam kept dinging and dinging and dinging. And it was Billy sitting right in front of the camera. He kept making the doorbell camera go off. From 1:22 a.m. to 1:29. The whole entire list is nothing but Billy sitting outside of the doorbell cam. So you can imagine how excited he was when I pushed the call button. And as I was walking out to let him in, I pushed the call button and I was like, "Hey, Billy baby." He like turned around and he looked right in the camera. I was like, "Come on home, buddy." And zoom, he went straight for the door. Nope, he's my boy. Yeah. Oh, it's a little chilly. I'm so glad he learned that trick, though. Hello, Elright. Oh, thank you guys so much. I just absolutely love all of you. And I can't tell you how much I enjoy this time together. I have cat fur on my face. Just can you wait until I'm done? You can cuddle up on me and get my face all fuzzy when I'm done streaming, because then I don't feel like a goofball as I'm trying to rub all the cat fur off my face. I don't even know what temp it is outside right now. It's been warm. I had the windows open again today, but it's supposed to be cooling down again. I'm not looking forward to that. Can I have my phone? No? Thank you. Yeah, it's 30 degrees here. Manny called it. He's pushing my elbow pads off the desk because they're in the way of him getting his pets. You got like sand and stuff on my desk, dude. Making my mouse make all kinds of crunchy sounds when I try to move it. I don't like that. All right. And I'm off. Thank you guys for being so wonderful as always. Be safe, be well, sleep sweet, and much love.